joint and several rule that was enacted 20 years ago. And so they have limited exceptions where you're automatically joint and several. One of those would be involving the use, sale, or possession of alcohol. That's incredibly broad. I think, involving the use, sale, or possession of alcohol is not necessarily the overservice of alcohol or selling alcohol to an intoxicated, visibly intoxicated person, those things, for example. And then the Smith versus Tiffany decision from 2017 goes at the modified joint and several rule, where the inability to put somebody who is at fault but not a named defendant on a verdict form and apportion fault to them. We think that just transfers that fault to any remaining defendant. They are then responsible not only for the damages they caused, but also the damages that were caused by other people.
Mr. Dubisky, you do know that under our current joint and several law, if you have a tort offender who pays more than his or her pro rata share, that they can actually go after a joint tort offender to recover whatever amount that they paid, beyond their percentage. So there's already, I guess, the current statute addresses your concern. To me, it seems.
I wouldn't say that always covers the full portion of the damages that the non-named party had caused, number one. Also, Supreme Court in 2024 talked about how those set-offs can be allocated in Jolly versus Fisher.
Okay. Thank you, Mr. Chair.
Any other questions?
Thank
We
you.
may have you come back up, Russ, but we're
Happy
going
to
to
do it.
let you go now.
Thank you very much.
Sidney Lynn. You would raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Mr. Chairman and committee, for having me here today. I am here on behalf of SCAJ. I'm serving as our association's president this year. I'm also a lawyer here in Columbia. I'm focusing my testimony today on the joint and several component. We understand there's a call to modify our current joint and several laws as a method to reduce insurance premiums. We want to be a partner in that process. We want to be a partner in finding a solution. My concern with the proposed legislation is that it unequivocally puts profits over people. And what I mean by that is that the insurance industry has created a very compelling narrative. They want us to believe that changing this particular body of law will lower premiums. But what they're not giving us is the evidence of that. So when I'm analyzing information like this, first thing I'm going to touch on is, what do we know? And so when we look at the history of joint and several liability, as Mr. Dubisky was speaking to, we know that the laws enacted in 2005 changed us from a pure joint and several legislative scheme to a modified joint and several legislative scheme. And what that means is a defendant would have to be found more than 50% at fault to ever be held 100% responsible for the verdict, notwithstanding after contribution claims after the fact. For more than 10 years after this legislation was enacted, liquor liability insurance premiums were not an issue. Then in 2017, this legislature enacted a mandate that requires bars and restaurants who serve liquor after 5 p.m. to carry $1 million in coverage. That is when we saw the rates go up. Next thing we have to look at, we know what we don't know. What do we know about the insurance industry? Well, to start, we know that across the board, insurance companies are realizing record profits. We know that the average salary of an insurance company CEO is $25 million. We know that the denial of claims is at an all-time high. And I would call everyone in this room's attention to the victims of Hurricanes Helene and Milton, the victims of the California fires. And we all, I think, would agree on the crisis that is now health insurance. When the medical malpractice caps were enacted in 2005, get this, premiums increased by 18% the following year. The CEO of Chubb Limited, his name is Evan Greenberg. I've got a quote from him. He's called for a prolonged tort reform campaign, and he says, "We are not going to address this simply as an insurance industry. We," referring to the insurance industry, "are not the sympathetic audience. It's going to take money and talent, and it's going to have to be approached like a long-term political campaign." Then I've got Douglas Heller, who is the director of insurance at the Consumer Federation of America. He said in the Wall Street Journal in 2024, insurers kicked their rates into high gear in 2023, which has been thrilling to investors. The third prong I want to touch on is, what do we know about other jurisdictions? What are other legislators who have been through this process? What are they telling us? Context clues, if you will. Republican Governor Larry Landry of Louisiana said in 2024, I'll quote him as well, "In 2020, the Louisiana legislature passed a comprehensive reform package known as the Louisiana Civil Reform Act of 2020. The insurance commissioner at the time, along with insurance and business lobbyists, promised that the 2020 tort reform would reduce car insurance rates by as much as 25% in Louisiana within a year of taking effect. Instead, car insurance rates continue to rise, which reminds me of the adage, fool me once, shame on you. Fool me twice, shame on me." If I'm in your chair, I'm calling Governor Landry and asking him for more information as to how that package was unrolled or unfolded and what impacts it did create. U.S. Senator from Missouri, Josh Hawley, I'm sure all of you have seen his letter. He wrote 2 weeks ago to insurance companies regarding the denial of claims made by American policyholders in the aftermath of Hurricanes Helene. And he says, "These reports of coverage denials are outrageous. Americans purchase insurance so that when disaster strikes, they will have some recourse. Denying coverage to American policyholders at a time when so many of them have been displaced and left grieving is not merely a betrayal, it is morally obscene." And that statement came in the aftermath of President Trump's visit to Western Carolina, where he invited victims, Western North Carolina, where he invited victims to share their stories publicly and to name the specific insurance carriers that were denying these claims. There's just no evidence whatsoever that this legislation in the joint and several capacity will do anything to lower rates. What we do know is that it will embolden insurance carriers and it will increase their profits. If the evidence existed, surely we would know about it. I'll leave you with just a quick little personal anecdote. When I was growing up in a small town in Aiken County, we used to get those fill in the blank birthday invitations. Y'all remember those? And once I was old enough to understand this process, my parents made me write no gifts on the bottom of the invitation. I lived in a small rural town. They never wanted any child not to come to our birthday party because they couldn't bring a gift. I didn't like that when I was 10 years old, but we did it, and we did it the next few years. And what I finally learned was that the reason they did that is because the disappointment imparted upon me was so much less impactful than the consideration we were given my classmates and other families in our area. And my testimony here today, I want to say the bottom line is our citizens deserve that type of unwavering consideration without fail. It should be at the forefront of any analysis. Thank you for having me.
Thank you. Any questions from the committee? Senator from Edgefield.
Just a couple. Hey, Sydney.
Hey.
Just a couple things. You referenced the 2017 passage of legislation requiring liquor liability insurance, and that we started seeing the jump in, or the problem thereafter. Fair enough. However, was there anything else relevant that happened in 2017 that could contribute to this?
Is that a trick question?
No, it's Page versus Tiffany, right?
Okay.
I mean, that also is very relevant to the conversation of rates going up, isn't it?
Sure.
Okay. And you referenced that statute, the 2005 statute, that says that a defendant must be more than 50% liable in order to then be responsible for someone else's. But it says defendant, doesn't it?
It does.
Right.
Mhm.
Which is the Page versus Tiffany issue, right? It says defendant. And I think for lots of folks who are not learned in the law, and I think a lot of people who voted on it, most people who voted on it in 2005 who are not learned in the law, there's a difference between a defendant who is a party and an at-fault party who is not a defendant,
Sure.
isn't there?
Sure.
Right. Okay. That's all I needed. Thank you.
Thank you.
Good to see you. Thank
Good
you.
to see you.
Anyone else? Senator from Berkeley.
Thank you for being here. I don't know if this is going to be a question or just a what you think, but wouldn't it be nice if an insurance company came in and denied any coverage whatsoever that they couldn't maybe operate in a state in? I mean, wouldn't that require more insurance agencies in to start covering people? In other words, they came in and say, okay, we're not going to cover your house because it's built on the ocean. We're not going to
Okay.
cover your house because of this. We're not going to cover you because a bar. Maybe we just say, okay, if you deny coverage, you just can't operate in our state,
That's right.
So, I mean, we have to get more insurance companies to understand they have to come back in to make this a competitive work field
Yes, sir.
and do some of these things. And so we need the information or whatever it is so we can work together in order to do that.
Yes, sir. So, and just to make sure we're on the same page, when I was speaking to denial of coverage, that would apply in situations where an insurer has agreed to insure someone already. I'm speaking more to the relationship that exists between insurers and insureds are backpedaling on that relationship, so to speak. Thank you.
Mr. Chair.
Senator from Richland.
Good afternoon.
Good afternoon.
Ms. Cindy. There's been much talk about the impact of insurance premiums, on small business owners. And in full disclosure, I'm an attorney. I do a lot of plaintiffs' work, and I think what gets lost is that plaintiffs' lawyers are also small business owners,
Sure.
and we employ a lot of people.
Sure.
And so I certainly sympathize, with bars and with restaurants, any small business owner, that, talks about, the challenges when it comes to insurance or any other challenges that one runs into when, trying to manage a business. And so I'm here today in good faith. I'm here with an open mind, and I want to find a solution. And I know you mentioned that you're here on behalf of Skage,
Yes, sir.
and that Skage wants to be part of the solution. And so I would ask you, assuming that you're speaking on behalf of Skage, what, if any, changes would Skage like to see, to, I guess, our tort laws in South Carolina? What, if any, recommendations does Skage have, or what does Skage want this committee to consider and take into account as we deliberate over this?
Sure. So I have a team of other folks here with me today to speak to different sections of the proposed legislation. And we have also been working on potential amendments to offer you guys in working through these issues. Went from a joint and several component. We think what we have is working. It's protecting victims in situations where minimum limits policies in a car wreck situation, for example, just would not be sufficient. The modified joint and several scheme that is in effect now was a tightening of sorts from our prior scheme. So we think that that should remain status quo. There haven't been any significant, runaway verdicts, or I want to say, in terms of settlements, people come to the settlement table voluntarily. So, I don't think there should be a fault assigned when settlements take a meeting of the minds. So really then what we're looking at is, what are juries doing? And juries, believe it or not, they usually get it right, and in the case when we do see these huge kind of runaway verdicts, what the general population doesn't always know is that there were some egregious acts on either the part of the defendant or the carrier, and perhaps those acts even rose to the level of bad faith. And bad faith is when we have an opportunity to punish a wrongdoer by imposing upon them a punitive assessment. And so I think I am in agreement that this issue is multifaceted, but what we have in place right now is not the problem.
Thank you.
Thank you.
I'm sorry. I have one question. No. Trust me, I'm looking around, but no,
Oh.
And thank you all for coming. All right. Yeah, and we have. So I heard your position as it relates to joint and several. What is the position of your organization as it relates to the Section 2, the liquor liability part? I mean, because we know that a law very similar to what is in 244 was passed in Alabama, and their ISO ratings went down, and therefore the rate premiums went down in Alabama. We know that it had a meaningful impact there. So I'm curious what position you all have on that issue, or if you want to defer that to the next person up.
Sure.
I get that, but I am curious.
Yep, I'm going to punt largely on that, but as a general statement, we need more information about what drives the ISO scores, because the information that's been presented to this committee this year and this similar committee last year says that, or indicates that joint and several liability laws do not lower ISO scores. Things like mandatory server training, other safety measures, I'll just leave it at that. Other safety measures could be implemented that would potentially increase ISO scores. But until insurance carriers give us a real clear-cut idea of how they're factoring the ISO score, how can we ever conform with a system that we don't know, that we don't understand how it's operated? That's my 2 cents on that part. I'll punt to my colleague for the specifics.
Anyone else? Thank you very much.
Thank you.
Jay Thompson. I know you have a hard stop time, so we'll try not to keep you up here all the way to it. Yeah, I'm with you.
Thank you, Senator, because that's an hour and a half
Yeah.
away. I hope not.
If you'd raise your right hand for me. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Thank you very much, Mr. Chairman, members of the subcommittee. My name is Jay Thompson. I am a civil defense litigation attorney here in Richland County. I'm one of the executive officers of the South Carolina Defense Trial Attorneys Association, and I speak here today on behalf of the 856 members of that organization as well. I am a shareholder with the Murphy and Grantland law firm here in Columbia. My comments today are directed primarily at Section 1 of S-244. Although if there are questions pertaining to other sections, I may be able to speak to some of those, but I'm here primarily to speak to the joint and several provision, similar provisions to what Ms. Lynn was just speaking to as well. My perspective is very different than some of the comments that were just heard. We've all heard the old saying, if it ain't broke, don't fix it. And I agree with that. If it ain't broke, don't fix it. But the reason I'm here today is because our current judicial tort system for apportioning fault amongst responsible parties is broken, and it doesn't work to achieve justice.
At best, it might work to what I believe to be a skewed sense of justice and what I believe to be a misguided policy in how we allow an injured party or someone who has suffered a loss to recover from others who are only partially at fault. S-244 is a good start to fix a number of problems that create injustice in our judicial system. It doesn't address everything that results in injustice in our current tort system, but it does a good job of taking a first step to addressing some of those problems. So again, I primarily want to speak to Section 1 of that bill that exists and the underlying problem that exists in our current tort system of apportioning verdicts against at-fault parties. This is not an insurance issue. And I think there was a comment made earlier that the joint and several provisions of the bill are intended to reduce insurance premiums. I'm not aware of that being the intent of Section 1 at all. The intent of the joint and several liability issues is fairness and justice, which our current system does not provide to us. This is not an issue of profits over people. This is an issue of a current system that per se holds individuals liable for negligence or wrongful conduct of someone else. And it is designed that way intentionally. That is part of what the Smith v. Tiffany case specifically confirmed. The existing statute is not ambiguous. It is written that way on purpose to hold individuals or businesses liable for wrongs of someone else. And I speak against that. I do not believe that is a policy that our state should uphold or pursue. As you know, under the current law, the apportionment provisions are in Section 1538.15. I know there's been quite a bit of discussion amongst that for multiple years amongst members of the subcommittee. The challenge, there's a number of challenges that arise out of the apportionment provisions in that section. But for those who may not be familiar with it, what that section requires a jury or a judge, if there is no jury, to do is to allocate 100% of fault in a lawsuit among the parties who are named parties to the case at the time the case goes to the jury. The jury is required to allocate fault in a way that it adds up to 100%, even if all of the 100% of at-fault parties are not there. So if there is a party who is at fault in causing the plaintiff's injury or loss, and that party was not named as a defendant, or that party was named as a defendant, but they resolved their lawsuit before it goes to the jury is not allowed to allocate fault to them, even if the jury knows unanimously they are the ones who were at fault. We have a very good jury system. I am a strong believer in our jury system in this state and in the United States, and I agree that the juries are really good at reaching just results. That being said, I think in every single trial I have had where this positioning of parties emerged, such that there was an at-fault party who was not a named party at the time it went to the jury, when we polled jurors afterward, the jurors told us they didn't understand how they were supposed to do what they were told they have to do because it confuses them, because they do not understand how I'm required to allocate 100% of fault when 100% of the at-fault parties are not here, and I'm not allowed to allocate fault to them. What we end up with in that situation is an unpredictable result. Maybe they get it right, maybe they don't, because they don't know how to do it. They guess. Sometimes they might reduce the overall verdict. Sometimes they might follow the judge's instruction, which is to award damages in a greater degree against a defendant who they know they are not assigning that much fault to. Sometimes they may do something entirely different. But that is what the current Section 1538.15 requires the jury to do. law as it is written today, which section 1 of 244 is intended to address, requires us to hold defendants liable for the fault of someone else. And I speak on behalf of the defense trial attorneys of this state, saying that's not justice. It's not fair. It's at best, it's rising out of an idea that we should be rewarding or providing recovery to an injured party without acknowledging who is liable for that injured party. Our elected representatives are asked to establish policy on issues like this. Here, what we have is a decision between two competing policies. On the one hand, the position that our law has had for a number of years now, it places emphasis on providing recovery to that injured person, to that person who suffered a loss, but without verifying that the recovery is coming from people who are actually responsible for that fault. It holds people responsible for things they didn't do. The other option, which is what S244 is trying to achieve, is focused on restoring that injured party, providing that recovery, while balancing the liability of all interested parties and holding the responsible parties liable for the things they are responsible for their own conduct, but not requiring them to pay for the wrongful conduct or negligence of somebody else. It's an effort to move, the S244 bill is an effort to move us in that direction. I believe it does a pretty good job of taking a first step, moving us in that direction. And I would encourage the subcommittee to move it favorably. I believe those are all the comments that I have. I'm happy to take any questions.
Any questions?
Mr. Chairman.
Senator from Edgefield.
Jay, I want to talk a little bit more about how the existing law actually works in practice.
Sure.
Okay, and you touched on that, but you have the trial. The judge gives at the end. The judge gives the jury a verdict form, right, which includes questions that the jury has to answer.
That's right.
Right. If there's a question of comparative negligence, that is, the plaintiff may have done something wrong. If there's a question there, then that's probably going to be one of the first questions that the jury gets asked, right? Do you find that the plaintiff was negligent?
That's correct. That's required to come up before the allocation issues.
That's right. If the answer is no, then we go to the defendant's negligence. If the answer is yes, if the jury thinks the plaintiff was negligent, then they're going to have to determine how much the plaintiff's negligence contributed to the overall. But in a situation where the plaintiff is not negligent, or even if they are, but let's just say they're not for the purpose of this example, then the question goes to, do you find that the defendant was negligent? Is that right?
Yes.
And in that situation, to your point, the question is not how much do you find the defendant was negligent? The question is, was the defendant negligent at all?
Correct. Yes.
Now, if there are multiple defendants remaining at that point, then the jury could get into some apportionment between those defendants, right? They could not, in fact, they are prohibited. The jury is prohibited from apportioning fault to non-defendants, to non-parties.
Yes.
So in your example, if it's an at-fault party who settled prior to suit, or one who settled prior to trial, who was a defendant, settled prior to trial, and the remaining defendant for some reason allowed that person to be dismissed, such that you go to the jury with just the one defendant. If the jury finds that that remaining defendant was negligent at all, 100% has to go on that defendant, doesn't it?
That is mandatory.
It's
required.
mandatory, right? The judge is going to tell them that. Right.
Yes.
I mean, it's mandatory. 100% is going to have to go, and then they're going to apportion damages, or they're going to award an award of damages.
Yes.
Right. The jury never gets to consider on the verdict form, and therefore in an apportionment of damages, whether non-defendants, non-party, at fault non-parties, what their portion may be, do they?
That's correct. They're not allowed to.
And because of that, then if the remaining defendant, let's say the remaining defendant, in the grand scheme of things, that the jury would find that that remaining defendant was actually 25% responsible for causing whatever the plaintiff's injuries were. In that situation, what the judge is telling the jury is that you have to put 100% on that defendant, because that defendant was negligent, but he was only, in the grand scheme, he would have been 25% negligent, but because the other 75% in there, that defendant gets 100% of it.
Correct.
So that's one point. But the other point is, and this gets to the a little bit of the conversation that Ms. Lynn and I had about the existing statute and the apportionment portion of it, that if you're over 50%, if a defendant is over 50% liable, only then can the defendant be responsible for paying all the damages.
That's correct.
Is that right?
Unless it falls within one of the exceptions where that doesn't apply.
Okay. Yeah. But in the example that we're talking about, which is not an unusual example, this is typical, the example that you've given, where you'll have some at-fault parties not sued because they've settled ahead of time, or you'll have some settled during the pendency of the litigation. It's not unusual that you have one or two defendants going to the jury. In that situation, when you got to put 100% on the defendants who are there, you're not going to get a situation where 50%, where less than 50% is going to fall on any one of those defendants, right?
The math doesn't work that way.
Right. Well, the statute's a trick. I mean, you don't have to characterize it that way, but it was written. It's disingenuous, isn't it? I mean, it's not telling the whole truth. It's not telling the jury the whole truth, and to argue to people that, well, look, the law already says, and I'm not saying this about Miss Lynn. I mean, I've heard this from other people because I've had senators coming to me and saying, well, look, the statute says if you're less than 50%, you don't have to pay. It's disingenuous, isn't it?
Absolutely. I've used the phrase self-contradictory in the past.
Okay. Yeah.
Sure.
And I suspect what was happening, I wasn't here in 2005. But I suspect what happened is you had a number of the advocates for that change who just didn't quite understand practically how it works in a courtroom. And they start making changes and they don't understand the consequence of them. And now it is to the point that it is effectively ineffective.
I agree with that, Senator.
Okay. I wanted to make sure that I understood how that works in real life, first off. But let's do another example, because I think there are people who are probably some people in the crowd, but also some people who are listening that this example may be more applicable to. Let's say you've got a terrible DUI situation. And you've got a guy who went to a couple restaurants over the course of the day and had some drinks at both restaurants. And then you got the guy who leaves whatever the last restaurant is, or at some point later on, maybe he goes somewhere else before he leaves, before this happens. But at some point, he's in a really bad car wreck, and somebody else gets hurt or, heaven forbid, killed because this guy is out driving after he's been intoxicated. Unfortunately, that is not an uncommon situation that happens. Yes. Right? In that situation, most of the time, the guy who gets drunk and then goes drive, hopefully he has insurance coverage, right? But in most situations, that guy's insurance company is going to pay that person's coverage fairly quickly. Now, sometimes the insurance companies screw this up and they'll sit on it for a while, or they'll do some things, and you and I have both seen this happen. But most of the time, they're going to pay pretty quickly, right?
That is correct.
So then what you're likely to have is that when a suit gets filed, is that the only defendants in the lawsuit are a couple bars, or maybe even just one bar, right?
Yes.
And then we get back to what we were talking about earlier, when the question, if it goes to trial, if the question goes to the jury, if you got one restaurant as a defendant at that point, when the case goes to the jury, if they think that the restaurant was in any way contributed to this driver becoming intoxicated and then him hurting someone else, if they think that this restaurant contributed in any way, they're going to have to put 100% responsibility on that restaurant that is the only defendant. Isn't that right?
If that's the scenario, that is correct.
Right. I mean, does that sound to you to be an extremely unrealistic scenario?
It's not extremely unrealistic. There is a nuance to that. What we
If I'm wrong, I want you to tell me.
Sure.
Yeah.
What we see in the specific type of example you're describing, where there is an intoxication accident, and the restaurant or bar is a named defendant, frequently, to be fair, we do usually see the intoxicated driver, if their insurance carrier tenders their policy coverage, it's usually not accepted, so that that driver can be kept in the case intentionally as a means of getting to those exceptions and circumventing the rule. Keep the driver in the case, then you work into subsection F. Now the joint and several doesn't apply at all, and any defendant who is even 0.1% liable is responsible for 100% of the verdict.
Well, in that situation, yeah, I mean, in that situation, if you have a driver, which happens way too often in these situations, if you have a driver whose insurance coverage is $25,000 and the damages are clearly much more than $25,000, then you've got a restaurant that's going to get hit for a good bit more than what the jury thinks it's hitting that restaurant for. Isn't that right?
Absolutely.
Yeah. And that is a product of the way the law reads now.
That is a mandate of the way the law reads now.
Okay.
Yes.
Thank you.
To be fair, if I may,
Please do.
we've heard I don't think we've heard the phrase today, but we hear the phrase in this debate, the empty chair. That is part of our resisting statute too. And it adds, when we have this mandated 100% allocation, it adds to the confusion of the jury, because the empty chair is section 153815 subsection D specifically allows a defendant to argue some other non-party was responsible for this. So the jury can hear that. But then the jury is simultaneously told, but you can't allocate liability to them, even if you think they were.
That provision too is disingenuous, right? I mean, it suggests that you can argue this empty chair, this non-party contributed, which you can do, but the jury then isn't allowed to apportion any of the fault to that non-party. So unless a jury determines that the non-party was 100% responsible, which means that the defendant had zero responsibility whatsoever, which probably isn't the case, right? There's probably some amount there. But unless the jury finds that the non-party was 100% responsible, the defendant is going to get 100% of the verdict.
That is correct. Thank you, Senator.
Senator from Richland.
Thank you, Mr. Chair. I'm just following the conversation between you and my good friend, the senator from Edgefield. And just to make sure I understand, it seems that the first example that was given, was we have a scenario where someone has already settled their claim with the insurance carrier, and so you have a defendant that remains, in the lawsuit, in litigation. Case goes, before a jury, and verdict comes back. And because you don't, and as you correctly pointed out, subsection D of the statute that allows the defense to, highlight or reference that there's another party that should carry some fault here. And the jury comes back, they hand down a verdict, and they don't have a choice. Well, they can't apportion fault. Is either the remaining defendant is 100% liable or not liable at all. Is that correct?
I understand that is the hypothetical. Correct.
Right. But and look, I'm the type, I'd rather not pass needless or superfluous legislation. And I say that because what I'm looking at is subsection, I believe it is subsection E, 1538-15 subsection E.
Set off section.
That's the set off section, which that's what's currently in the law, but under what's being proposed would completely eliminate, that section. But it provides for a set off from any settlement or judgment, for any settlement rather, that is paid out prior to a jury verdict coming back. So again, sticking with the example, that's been that's out there. The remaining defendant who is held 100% responsible, he or she would be entitled to a set off, right? Up to the amount that may have been paid by the insurance carrier for the other tort offender or tortfeasor, right?
Yes, and the devil's in the details on that.
Okay, well,
because
please explain, because it's my understanding with set offs,
sure.
and if the verdict comes back $100,000 and the other defendant, settled, prior to litigation or prior to the verdict, let's say they settled their claim for, I don't know, $90,000. Well, the remaining defendant would be entitled, at least under subsection E, to an offset of $90,000 that's applied toward that $100,000 verdict, although the jury held them 100% responsible, right? So to me, it seems that subsection E, which is the current law, would assuage, the concern that you've expressed. But, I'm certainly willing to hear from you on that.
And there's two primary considerations that have to be taken in regard to that. One is that by law, a set off can only be set off for some other settlement or recovery for the same injury, the same cause of action. What we see in my experience more often than not is an earlier settlement is usually specifically allocated to one cause of action. And then with the remaining defendant, the plaintiff intentionally proceeds to the jury against a different cause of action, which 100% eliminates any set off, because you can only set off the same settlement for the same cause of action. So you might see that in a wrongful death and survival claim. The settlement might be for one, and then they proceed to the jury against the other, zero set off. There's plenty of other circumstances where you might see that as well. The other nuance to that, which is, I'll characterize it as a number crunching issue. Subsection E specifies that the set off shall be applied in proportion to each defendant's percentage of liability, such that if there are multiple defendants that go to the jury and the jury returns a verdict against multiple defendants, they can only set off their percentage allocation of the earlier settlement. When you actually crunch the numbers on that, more often than not, the defendants combined don't get to set off the full amount of the settlement. So what the recovery, the plaintiff actually gets when you add up the pretrial settlement and the amount they get from the verdict is greater than the amount of the verdict. So the set off doesn't actually result in a full set off. That's just a matter of how the math works out most of the time when you have multiple defendants that go to the jury.
Thank you.
Also on that point, or related to that point, with regard to the comment that was made earlier about a defendant's ability to seek contribution or recovery after the fact from another, Section 1538-50, which is in the same statute but a few sections later, it actually prohibits a contribution action against a earlier settling defendant. Yeah, against an earlier settling defendant. So if defendant one settles with the plaintiff, defendant two goes to trial, defendant two is prohibited by 1538-50 from seeking contribution against defendant one. Statutorily impossible.
Mr. Chair, is that something you think this committee should consider?
My understanding of the way S-244 is drafted is it would eliminate that problem.
It's not my understanding of the way it's drafted, but is that something you think would that would be
The
helpful?
way I read it, I read it to eliminate that problem in the way it treats 1538-15 and then the proposed repeal of 1538-20, 30, and 40, because they're subsumed into the new proposed language of 15.
I've got.
I'm sorry, I didn't understand.
I'm just thinking in my head for a second. I have not walked into a courtroom in a long, long time. And if I do walk into a courtroom, something has gone terribly wrong in my life. So I say that, but I do want to just kind of walk you through a scenario. You have an injured worker at work, settles their workers' comp case. I'm going to use simple numbers, gets $10 on their workers' comp case. By statute, the employer has a lien on the entire $10. They get their money back on a third-party case that is brought. Under this statute, specifically the new section 1 under 5838-15, it says the jury may not be informed of any immunity defense that is available to the non-party, because by law, an injured worker cannot sue their employer. That is the law in South Carolina. So now we go to the jury, and the jury awards us $12. Let's say it's $12. And they apportion fault of the non-party, AKA the employer. They say, that employer removed some safeguard, did something, and we find them to be 40% at fault. The reality is that injured worker is going to get less money out of the jury. That's going to be offset, but then they're still going to have to pay back the lien at 100%. So my question is, if you're going to put someone in that scenario, and those cases happen a good bit, if you're going to do that, shouldn't there be some fault attached to that employer, thereby offsetting any lien they might try to recover on? You following me?
I think I'm following
Yeah.
you. And that's a scenario, I'll be honest with you, I haven't thought through before you're presenting it to me at this moment. The provision of not notifying the jury of immunity, I can see how it would result in that scenario, and perhaps thinking this on the fly, perhaps the not notifying of immunity issue may be where there's room for flexibility there.
I'm also, and I've learned that the time it takes me to leave my house, the time I pull into the parking garage, everyone in Columbia wants to call and talk to me, specifically about tort reform. And so one of the things that has been, what it was asked me was, you have a distributor of a product fails, someone is injured because of that, but the maker of the product is in China. I can't sue them. I can't get to them. I have no access. They're not only a non-party defendant. I couldn't sue them if I wanted to. I don't have access to them. And that the way this is written and being allowed to say, oh, there's a company in China that's really the problem here, could end up in having an unjust result for the plaintiff. And I get that your testimony is the pendulum is here. Mm-hmm. What I don't want is the pendulum to go here. I am happy if it would go here, right? I mean, and that's our task, but I don't want to all of a sudden take a system that's bad for you and now make it bad for people who were injured for things that weren't their fault. There has to be a middle ground somewhere. So I'm curious, how do you handle that on the, what's your thought process on handling that on a verdict form?
Sure, that's a great question. The scenario of an international entity that you just can't get jurisdiction over has been a perplexing, mind-boggling issue in our tort system for as long as I've been part of it. It exists today. We're not going to find an easy solution to that, especially in countries where you can't go through the Hague Convention to get to them. If you can go through the Hague Convention to get through them, it's still a hassle. It's not easy to do. In my opinion, that scenario, let me back up and say it this way. By its very nature, legislation is not going to address every conceivable instance that could happen. There's always going to be an instance where someone says, well, that's a unique scenario. I believe this is one of those. However, I believe if it's a big enough concern, it is possible to put in a specific provision that applies to that scenario. Whether there is an international entity or some entity that for some reason the court cannot acquire jurisdiction over it, then you can instruct the jury to those things. I would not have a problem with that. And I believe that could be handled in a subsection.
Fair enough. Let me ask you one other question, and then I'm going to let the senator from Edgefield, who's much smarter on these issues, ask the next question. When you talked about E a few minutes ago, subsection E, which is being stricken, could we fix all of this just by fixing that one paragraph?
Just by fixing E?
That just by fixing E, because that's the set off. So if the question, when you describe that, oh, well, I settle for 50 with this guy, I get a jury verdict for 100, and I get 100. I actually got more than the jury ever meant for me. Is the fix something along the lines of saying you just can't recover more, period, than the jury brings back, as opposed to saying, hey, you're entitled to 150 when we really only thought there was 100 there?
I don't believe so. I believe that's attacking a small subset of the problem rather than going to the center of the problem. For example, that doesn't address situations with an at-fault party who is never brought into the lawsuit in the first place for whatever reason.
Couldn't you bring them into the lawsuit? I mean, you
That's
have that, and we could make it where you automatically had that right. It could not at a discretion of a judge. We could just say, no, it's your automatic right to bring in a non-named defendant if you think they have fault.
To allow a defendant to do that would be a substantial change from what we have today. I believe it would require carefully analyzing the potential ripple effects of how that might play out, because our existing civil procedure rules and statutory rules are pretty rigid that no, a defendant cannot bring in additional parties unless they have a cause of action against them. You can't bring in an additional party just because you think that party is at fault to the plaintiff. The plaintiff gets to choose who they sue. That's how we are today. So that would require a substantial change that would have to be analyzed very carefully.
Thank you, sir. Senator from Edgefield.
Thank you, Mr. Chairman. To your, and I don't know if this is really a question for Jay, but to your question about the foreign involvement, it's not fair for an injured person not to be able to recover the full amount of his damages, right? It's not fair. I don't know that you cure that unfairness then by allowing for the recovery of against an at-fault party of more than what that at-fault party caused. The example that you gave, it's not fair that the person can't recover from the Chinese company. On the other hand, what your proposal is that the person could then recover from the known defendant more than the known defendant's responsibility. And I don't think that's fair either. Now, I'll absolutely concede that the scenario with your injured party, it's not fair. I don't know how to fix it. I just don't like the solution that's been out there that, well, because we can't recover against him, then 100%'s got to go on somebody else who didn't cause 100%. That's not fair either. And I don't know that you cure one unfairness with another unfairness. So that's a hard one that I haven't been able to figure out. But the current law allows for the one party to be 100% responsible, even if we acknowledged he didn't cause all 100%. That's not fair either.
Any other? And I don't disagree with you, Senator from Edgefield. I struggle with that more than anything else. Is I see the underlying issue in that he who buys the most insurance is the loser often. And I don't, but part of this is risk. We are trying to balance risk across a system. And the question becomes, who is best at balancing risk is and inside of that system. And it often that's what insurance companies do. They're just balancing risk. And I don't want to see someone who, I don't want to get into a scenario where all of a sudden there are parties we can't get to who have such significant negligence that you are diminishing the recovery of someone. And then all you've done is shift that risk to the state, because the state through various social programs will pick up those bills, or those bills won't ever get paid. And then healthcare, I mean, there's such a ripple effect. And if I had the answer, I'd already put up an amendment and talked about it, but I don't have the answer. So I'm looking to the crowd for the answer.
Yeah, I don't know. I don't know what the solution there is either. I mean, I've thought about that scenario, and I think it's a real scenario. I mean, I think it could certainly exist. I think it does exist at times, even if you're not talking about a Chinese company. I mean, you can have domestic companies or individuals for which there's no ability to recover from those individuals. But it's also not just about insurance. I mean, I know there are people who want to keep the focus on insurance, but that's not really what it's. I mean, it's about that partly, but it's not what it's all about, because the individual in your situation, the one that we can get to, right? The American, the one that we, right? Regardless of whether he has insurance or doesn't, or how much insurance company has, or how much he has, it's about what fault does that person have. And if he doesn't have insurance coverage, or if he has insufficient amount, it could be that person's personal exposure potentially. And it's not fair to make that person pay more than what he caused. In addition to that, even if we are factoring risk, and this gets in way above my head, right? When you start talking about insurers dealing with that stuff. But look, the guy in your situation, he pays the premiums, right? I mean, he pays the premiums to cover his liability. He doesn't pay the premiums to pay somebody else's, at least he shouldn't be. And then if his carrier is going to pay out more than what his liability is, then he's going to have to pay for that as well. And that seems to me to be, he's going to have to pay increased premiums because of somebody else's at-fault conduct. Anyway, this is a hard one, and I don't know what the answer is. I mean, I see inequities on both sides of this one. And this is something that, I mean, I'm glad you raised it, because I think it's something that we're going to have to spend some time looking at. I want to make it as fair as possible. This is one that I haven't been able to figure out.
Anybody? Thanks. I know you have a leave, and you have a little. We may end up having you back up. So if you hang around for just a couple of minutes, I promise you, I'll get you out long before 2:30.
Thank you for your courtesy.
Yeah, you could run. I mean, just turn off the lights and take a bolt. Real fast. Ashley, are you the counterpart to this? All right, Ashley Creech, come on up. Ashley, if you'll raise your right hand, you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you.
Good afternoon, Chairman and Senators. I'm Ashley White Creech. I practice law in Rock Hill, South Carolina. I'm president-elect for SEAJ. And I have sat in this room over the past, I guess, year and a half, 2 years, and listened to business owners and bar owners and victims testify, and I understand that we have some real problems and think real problems need real solutions. Non-parties on the verdict form doesn't serve the purported goals of helping businesses get lower insurance rates, of discouraging frivolous litigation, or in protecting victims. This isn't just about insurance. It's about people. It's about people who own businesses, and it's about people who are hurt through no fault of their own. It makes non-parties on the verdict form make small businesses, not these large corporations can generally hire lawyers, but small South Carolina businesses more vulnerable to lawsuits, more vulnerable by the logic underlying this bill to higher insurance costs and to financial instability. It undermines also, and I think most importantly, the rights of South Carolina citizens to have a full and fair trial by a jury of their peers. I agree with Mr. Thompson on not a lot, but one thing I do agree with him on is that we have really good juries in South Carolina. And I have a lot of faith in our jury system, and I think that they generally get things right. And I've tried cases and I have won some, and I've tried cases and I have lost some. And I've always been just amazed how jurors really can get to the heart of an issue in a case. What this does is invites trial by ambush. It is so easy to point the finger at someone who's not in a room, right? And the difference here is, and with no burden of proof, so right now for a plaintiff to prove their case, they have to present evidence, more likely than not, their extensive jury instructions, and that's gone, yet someone could end up on a verdict form. Currently, the law carefully balances the interest of public safety, and that's one of the purposes of our tort system, right? To compensate victims, but also to keep South Carolina communities safe. It compensates injured parties, and it gives businesses predictability. Senator Massey, you pointed out, currently, if a plaintiff's more than 50% at fault, even if someone was negligent and their negligence contributed to their injuries, they get zero, no matter how bad the damage is. If a business pays more than their fair share, they are able to get contribution to recover some of that. And the system encourages parties right now to work out disputes among themselves. And they're in the best position to do that because these are the people who were involved in whatever incident occurred. So, they can work it out amongst themselves. Settling defendants know with confidence, they have predictability that the case is done. And non-settling defendants get the benefit of a set-off. Regarding Mr. Thompson's point regarding apportionment, you see people putting everything on wrongful death so they can maximize the recovery for the plaintiff. Well, of course, a lawyer is going to try to maximize a recovery for the person who's been injured. But practically speaking, defendants have an opportunity to challenge that apportionment. I have had that happen where the judge said we had divided up a settlement as to wrongful death and survival. And so based on the jury's verdict, I think the defendant, if the judge honored the apportionment, would have been entitled to roughly $50,000 set off, but the judge gave them the benefit of the entire set off because the defendant had them reapportion it. Employers under the current law, and Senator Johnson, you pointed this out, have a solid workers' compensation system. They know they are immune from certain types of at-fault lawsuits. And we have a system that allows them to get reimbursement from third parties. Now, even with that immunity, they can end up on a verdict form. And businesses like predictability, and that's bad for business. And they can end up in that verdict form without having any opportunity to fully and fairly defend themselves and without there being a burden of proof as to that finding. I do a lot of medical malpractice, and before our clients can sue a physician, we have to find an expert witness, get a sworn statement from someone in that same practice area, then file a notice of intent to file suit have a pre-suit mediation. And it's because that it's stressful, right? To be named in a lawsuit that can affect their practice. If we go to trial and there is a verdict, that has reporting consequences to the National Practitioners Data Bank. But there is that layer of security for them knowing that before a jury can find them responsible for causing an injury, there are all these practices in place, the purpose of which is to discourage frivolous or lawsuits that don't have merit. Now, a medical professional could end up on a verdict form. A jury could apportion fault to them. And that could affect their business. It could affect their medical license, and it could have NPDB reporting consequences. The practical effect of this bill is that it's going to encourage litigation. And the answer to too many lawsuits is not more lawsuits. And that's what will happen here. It's going to hurt businesses, number one, but number two, it's going to hurt victims. And I think particularly, there's been a lot of talk, I think, of DUI and drunk drivers, but let's talk about Ponzi schemes and financial crimes, the victims of which are typically our elderly population, and sex crimes, the victims of which are typically children. And I'm a mom of 3. And if a school has a sexual predator, I think they have a responsibility. And if they violate that responsibility, I think it's horrible for victims that they would have to bring in the sexual predator now. It's going to penalize those victims. In trucking cases, farmers are now going to get sued for loading the truck incorrectly, because if they could end up on the verdict form without a burden of proof, that's going to happen. In medical malpractice, a lot of times as professional courtesy, medical residents are named. They're going to be coming in. In construction cases, the local subcontractor who played a minor role is now going to be named. What's that going to do to insurance premiums? This is going to discourage settlements. Why on earth would someone settle a case if they are going to then have to deal with this, the lack of predictability that they could still end up on the verdict form? There is a huge business value in confidential settlements. I like to think that as a community, most of us want to get things right. If we do something wrong, we want to take accountability, say we're sorry. And if it's resulted in damages, that's why we have insurance. Compensate the victim for that. And for a business, avoid bad publicity. Now it's going to be very difficult for cases where there are multi-defendants to resolve a lawsuit. Additionally, it's going to give opportunities for our judicial system to be manipulated. If you think about a large company that maybe has to dispose of hazardous waste, well, a sophisticated company might form a separate entity to handle that responsibility, underinsure that company, provide no assets to that company, and then at trial say, oh, nope, it wasn't us. It was this small other organization. I have listened to insurance experts testify, the director of the Department of Insurance testify, and one of the themes that I've heard is that with raising insurance rates, we need a system that has predictability and control, and this does the opposite of that. By the time a case gets to a jury, and the vast majority of cases settle in South Carolina, and I am so curious there's not these huge runaway verdicts happening throughout the states. I think statistically, particularly in the area I practice with, the majority of cases end up with defense verdicts. The parties have gone through discovery, often years of discovery, had depositions, talked to the people involved in the case, and then defendants and plaintiffs get to have the case heard under the Seventh Amendment by a jury of their peers. Now, a business owner could be fully unaware that in a courtroom across the state or across town, a jury is holding them liable, even if there would not be a payment, but making a finding against them with no burden of proof and without them having the opportunity to fully defend themselves in the courtroom. This is a verdict for all time. I mean, it's part of the public record, and I think that matters. These juries are the people who elected each of you to serve. You have the privilege of representing them, and they have common sense, and their verdicts reflect that. If someone outside the courtroom is at fault, what we see are defense verdicts. And Senator Massey, you use the example of a bar owner where the drunk driver was not named. That case tried last year in Horry County and was a defense verdict. A case with that same factual scenario. Additionally, I think there is this narrative that someone can be 1% at fault, right? And then be held liable for more than their fair share of damages. The scariest part for me when I'm trying a case is when the judge reads the jury instructions. Well, I take that back. The scariest part's probably when the jury leaves, but the second scariest part is when the judge reads the jury instructions. Yeah, fair enough. When the judge reads the jury instructions. And the judge is telling them the plaintiff has the burden of proof. Before you can find and award damages, you have to find that the defendant had a duty. They had a legal responsibility to the plaintiff, that the defendant breached that duty, and that just in simplest terms mean they acted unreasonably, and greater than 50%, that defendant's conduct substantially contributed to the plaintiff's damages. They are 100% at fault before we get to damage apportionment. This is not a liability apportionment. It's a damage apportionment. And I think when someone violates a duty, and a jury of their South Carolina citizens finds that, we're going to invite litigation, and it's not fair to get rid of that burden of proof and those protections that belong to the defendant, right? Or to allow the defendant to come in with no burden of proof, with no knowledge to this third party. Like I said, it's easy. I have 3 kids, and my son is wild, right? And so if my girls are very good about something happens, he did it, right? And you know what? He's kind of naughty, right? So a lot of times it's easy, we've had to stop and say, no, let's look at it. But when he's not there to defend himself, that's an easy ask. So it's patently unfair to everyone involved. And Smith v. Tiffany did not change South Carolina law. I think my very first jury trial was in 2017. And this was when I think there were a lot of questions about how the law worked. And the judge was very clear, no non-party on the verdict form. Currently, if a non-party is responsible, or the defendant believes the non-party is responsible, the defendant can argue that all day long. And that's a protection for defendants to keep them from being held responsible when they are not at fault. but it takes it a step too far to allow that to go on the verdict form. This doesn't serve the purported goals of this legislation. It's going to invite litigation. It's going to put small businesses at risk. And it's also going to shift the burden for undercompensated victims back to the state of South Carolina.
Thank you, Ms. Chairman. And I don't know that I have a question necessarily. I appreciate your comments, and I know you did a lot of work on this. I appreciate that as well. I don't know that I have a question necessarily, but a couple of comments. First, I agree that Smith versus Tiffany didn't change the law. But what it did is it changed what nearly everyone who voted for it thought that it meant. And that's because they did a poor job of writing it. I think it's because there are also some people who were voting for it who got tricked into thinking that it meant something different than what they actually thought what they were voting for. But I agree, and I think Kittredge did a very good job of explaining how the legislature really screwed this up. So I don't disagree that it didn't change the law. I think it was a correct interpretation of the law. However, I think that interpretation of the law was different than what everybody thought they were doing. And ever since Smith versus Tiffany, the real focus has been just on that issue and just trying to get back to what everybody thought they were voting for in 2005. And I realize you're the incoming president, but I will tell you that ever since 2017, there have been multiple efforts to sit down and talk about this in a good faith manner, and the response has always been no. All right. And now we're in a different situation. All right. And that's just kind of where we are. Also, I'll say this, so the part about putting non-parties on the verdict form is something that I knew we were going to have to spend some time working on. There is nothing in there now that says that there's a judgment or a verdict against a non-party. So there is no responsibility for the non-party. It's not going to affect their insurance rates because there's no verdict against them. However, having said that, I'll tell you this. I'm willing to work on that language, right? The part about burden of proof, I'm willing to work on that. I'm willing to work on all this language. I'm not willing to remove it, but I am willing to work on the language such that it will be effective in a courtroom, but I'm not willing to remove it. So I understand there's a lot of opposition to that language, and I'll just say I'm willing to work on it to make it work, but I'm not willing to remove it. And that's just, look, the numbers have changed, y'all, right? We had opportunities to talk about all these things, and the numbers have changed. It's a different day. And so that's why I'm not willing to remove it, but I am willing to talk about it in a way that'll make it work. So that's where I am.
Senator from Greenville.
Thank you, Mr. Chairman. Ms. Creech, if you know, are there other jurisdictions that allow non-parties to be placed on the jury form, the verdict form?
I have not done a full 50 state survey, but yes, I know that I believe Florida, Georgia, and West Virginia do. What I'm not sure about is because it's a very complicated issue because we have lots of provisions that this affects, like workers' compensation, right? Professional negligence. And so I think this is so South Carolina specific that it's difficult to discuss. My general understanding from the attorneys that I have spoken to in states where there are non-parties on the verdict form is that it is extraordinarily confusing. I personally have never had a jury ask a question about being confused about how to fill out a verdict form. My understanding that's commonplace now. So I think the likely outcome of that is going to be a clog of just trials because it's going to discourage settlement, followed by a backlog in our appellate courts.
I get it. It's not apples to apples, and it's very difficult to take something that's happening in another state because just our underlying system as a whole. But anybody who has a thought on that or an idea how we could take what works in other states, taking into consideration our negligent system as a whole, and answering some of those, because I mean, the way you describe it, it would be a unpleasant situation, but I'm sure there are other places that do it differently than we do, and maybe could address some of your concerns.
Any other questions? Senator from Richland.
Thank you, Mr. Chairman. And good afternoon to you, Ms. Creech. And, I have, some heartburn, about adding a non-party, to, the verdict form. But as the senator from Edgefield said, it's language that he's willing to work on. And, what comes to mind to me, at least what I would analogize it to, sort of like in, criminal cases, where a defendant can, allege, third party guilt and say, well, it wasn't me, it was someone else, and argue that to the jury. And pretty much that's tantamount to, well, I would say subsection D of the statute. That's pretty much tantamount to what we've seen in criminal cases, right? Where in a civil case, defendant could say it was someone else. In criminal cases, third party guilt, a defendant can argue to a jury it was someone else. But the difference is in criminal cases, you don't get to add the name of a third party, to the jury form. When the verdict comes back, it's either guilty or not guilty. It doesn't say, Overture Walker and, John Doe, right? It's the person who has been indicted or the person who has been, arrested and charged. And so, and I don't know what they're doing in other states on the civil side, but to me, this certainly is a significant pivot from the way I've always understood our justice system to operate, whether it be on the criminal side, whether it be, on the civil side. And, again, to me, we already have in the statute, protections for defendants where they're able to argue in a civil case that it was someone else, just as in criminal cases. But again, in criminal cases, you don't get to put the name of someone else on the verdict form.
I think that's right. I mean, and I have two just sort of clarifying points. I think at the end of the day, the name being on the verdict form with no burden of proof, with no affidavits of merit, what type of notice do we have? Because the discovery process, it takes a case in South Carolina anywhere from 18 months to 3 years to get to trial. So there are so many sort of baked in notice issues there as well that would need to be addressed. And I think it's a complicated issue to be addressed. I think one area that would have clarity is, there's an issue of addressing rising insurance premiums, which we've heard is one of the purposes of this litigation, and addressing fairness for defendants, which is one area here. But I think any solution would also need to address the sort of community safety in South Carolina. Like I said, I have children and we have a bunch of toys in my house. The vast majority of them were made in China, right? And if one of them injures, how do we address these issues? And any solution should not be at the cost of victims.
I think you would also agree that at least the legislation as it's proposed would also shift the burden, to the injured victim to actually track down, this non-named party to recover damages as well.
Yes, and I mean the burden should lie with the party who's alleging fault, not with the plaintiff who has pled their case. It's very easy to point the finger at someone who's not there to defend themselves.
And I think that may create another challenge when you consider that this person has not been named as a party, yet fault has been apportioned to them. And so the question becomes, especially after the statute of limitations is run, how does a plaintiff then recover from the unnamed party, right? When they're not a party to the action?
Absolutely. And, generally speaking, that's absolutely true, just due to the timing of the lawsuit. But just in a bigger picture, I am not aware that this is even a problem that needs a solution. I mean, there aren't most cases that end up going to trial. When I've tried a case and it's a case against a physician, but there is possible nursing negligence, we lose that case. I think it's sort of like, be careful what you wish for. This is going to invite more lawsuits and more litigations. That being said, we are always happy to have discussions. We just need clarity on what the intent, what is the goal for this legislation.
Thank you, Mr. Chair.
Well, I'll just say to that last point, I appreciate that you and Miss Lynn are in the positions that you're in now, because I will tell you absolutely that has not been the position since 2017. Right? We had to fight like hell to get some really meaningless protections for COVID liability in 2020 and 2021 that really didn't mean a whole lot, but that your predecessors just absolutely refused to talk about. Right. So I appreciate your position. I appreciate Sydney's position being there as well. And Sydney and I have had some conversations already, and I look forward to working with you. But the problem that you now face is that your predecessors consistent refusal to even have conversations have now created a position where, look, we're in a different situation now. Right. And I'm willing to talk, but I'm not willing to do nothing.
I just want all of the conversations to serve South Carolina citizens. I think that's got to be the goal, right? And that includes business owners, bar owners, and victims. And
whether you believe it or not, so do I, and so do we.
Good.
Right now, our interpretation of what best serves may be a little bit different. And you and your folks, the people who enjoy Twitter, who are not brave enough to actually be here and say things in person because they can do it from their mother's basement. They can say whatever they want, and they can call us all corrupt or all on the take or whatever. But again, I'll tell you, I'm willing to have good faith conversations. I'm not willing to have bad faith conversations. And if there are people who just want to continue to say no and not want to talk, that's fine too. Because I'm at the point now where, very candidly, multiple offers have been made. The time limit has expired. I'm perfectly happy going and trying this case because the jury's different. And I want to make sure everybody understands that, right? This is not a no, we're not going to do anything scenario. There is no way that this body does nothing.
I don't have Twitter, but
I don't pay attention to it either. Everybody likes sharing things with me, and I don't really care.
Sure.
Frankly.
But understood.
But I will say, look, again, I'm willing to talk, but I'm not willing to do nothing. Okay.
Senator from Berkeley.
So when you were just commenting about the citizens of South Carolina, and you mentioned businesses, citizens, and the bars, we do have to watch out for them, but and also hold accountable who we need to hold accountable. But one person that keeps escaping from being held accountable is the adult on the other side of that bar, who seems to never be mentioned in a lot of the lawsuits, and they escape because everybody's going after the bar or business because that's where the money's at.
If we want to address rising insurance premiums that we've heard in many subcommittee meeting hearings, right, are hurting ability to practice business. And I think that's a very real concern. There are ways to do that. I mean, Alabama went from a strict liquor liability statute to a voluntary intoxication standard that lowered their ISO score, which should lower premiums. And I think that's where that focus for those groups, I think that's important. And I think that should be part of part of the conversation. Additionally, rate regulation is a potential solution. So in terms of non-parties on the verdict form, I think in practice, if the drunk driver's not named, I think a lot of times that just results in a defense verdict. But also, I think we need to keep in mind, my son has Nerf guns, right? And if he shoots those at his sisters or our dog, it's not a big deal. He just got a BB gun, right? And so what does he have to do with that? He has to exercise more caution. When we are talking about alcohol, that's a controlled substance, and we all know that the irresponsible use of it in any format can have really dire consequences. So I think there has to be that balance as well. But there are practical things that can be done that would lower insurance rates for bars and restaurant owners. I have just seen no evidence that that solution is non-parties on the verdict form.
Thank you. I'm going to get Jay, if you'll come back up. I know you've got a hard stop. I want you to be brief, but I'd like you to kind of address one part that kind of struck me out of Ms. Creech's testimony is how do we put the non-party defendant on the form? What's that procedure going to look like? What's the ability to add? And because the way I said, you have two classes of non-parties. You have one that has settled, right? I've settled out of this case. I'm not here today. And then you have a amorphous, this is the guy who's to blame. And at what point is that person identified and the plaintiff perhaps has the opportunity to bring them into law? So if you can address that, at least it would, because in my mind, I don't understand how that procedurally is going to work. And so I'd love to hear that.
Great question. Thank you, Mr. Chairman. And if I may, in 5 seconds before I respond to that, you can take Ms. Creech at her word. She and I have known each other for, I think, 20 years. And if she tells you she'll come to the table and talk, she will. She's trustworthy, and she's a very, very good lawyer. So you can trust her. She and I are on opposite sides of the V, but she's trustworthy and a very good lawyer. So you can take her at her word. I think you and I actually may have had a discussion about this issue last session, perhaps, because the mechanics of how it works were more in the bill that was presented last session than they are in the current bill. There were discussions about providing notice a certain number of days. Maybe it's a certain number of days before trial. Maybe it's a certain number of days after the complaint is filed, that sort of thing. I believe the answer to the question lies in something that looks like that. The mechanics of providing notice to the other party X number of days before trial. We propose to put entities A, B, C, and D, or just this one, on the verdict form as a proposed non-party who is at fault. That can and should be done while there is still an opportunity to do discovery on that by both parties if they choose to do so that everyone has plenty of notice, plenty of opportunity. Everybody knows exactly what's going on. You have full disclosure. As far as if it's going to affect burden of proof issues, I don't buy this idea that it's putting someone on the verdict form without a burden of proof to prove their fault. I think that's the exact opposite of the basic concept that a plaintiff has the burden of proof and always had in the history of American jurisprudence. The plaintiff has the burden of proof to prove who is at fault. Always has been. And if the entities that are at fault are non-parties, well, the plaintiff has the burden of proof to prove that the entity they sued is at fault. Part of that is, if there are these other parties out there, you got the burden of proving that. It has always been the case, that, and it is now, that the defendant has the burden of proof. If they want to raise certain defenses, the defendant has the burden of proof on those. I don't see that there's any issue there. That doesn't change anything. So I think the question that, Mr. Chairman, you're raising is a mechanics question. I think you handle it by notice provisions within maybe within a civil procedure rule, probably within the statute that addresses it in that way. You conduct discovery on it, and then you have mechanics of exactly what is going, who can go onto the form and why, that sort of thing.
Would you agree with me that the current bill as written doesn't really prescribe how that's going to happen? And
It does not.
I like to always try to, when I'm voting on larger things, how the real life application of this, and how you are going to say at some point to a plaintiff, I think this was X, and the opportunity of that plaintiff to respond so that it is equal to other, and maybe they add them as a party. Maybe they say, nope, I'm willing to take my chances. Let's walk in the courtroom and see what happens. So I would love, and perhaps this is that opportunity for each side to have that conversation, is what is that procedure? Maybe you sit down and you kind of walk it through amongst real trial lawyers, people who are trying cases on a day-to-day basis on both sides, and tell us what's that going to look like? Because I'm not sure that the rules of civil procedure are going to be up to the task under the current bill to really lay out and prescribe how that process is going to happen. If we're going to do this, let's have a clear cut. You can't in the 10 days outside of trial file your motion and say, here they are. That there is an actual process so that each side has that balance. And I would hope and encourage y'all to sit down and talk about it. Are there anything that you just like to testify in general? You heard Ms. Creech that you're like, we don't necessarily agree with that, and kind of a why. And if anybody on this committee has a specific thing they'd like to have him address, please feel free. But Senator from Richland.
Mr. Thompson, you heard me make reference to this a few minutes ago, but under the scenario where we are adding an unnamed party to the verdict form, and statute of limitations has run, we're 3 years out, case has gone to trial. The defense has put plaintiff's counsel on notice that, hey, we're going to add John and Jane Doe to the verdict form. Case gets tried, verdict comes back, let's say $100,000, and fault is apportioned, right? And I guess my question for you is, what would be the mechanism for a plaintiff to collect from a party that they did not sue, considering that the statute of limitations has run?
Sure.
Right? Because the only way, as I know and all the lawyers in this room, the court is not really, I guess, endowed with jurisdiction over that person until a lawsuit has been filed. I didn't sue that individual, but yet a jury has determined that that individual is 100%, responsible, for the plaintiff's, injuries. So under that scenario, what recourse does an injured victim have to collect from, that defendant, that unnamed defendant?
Great question. Thank you. I believe existing law covers a lot of that. If a plaintiff chooses not to sue that defendant and chooses to let the statute of limitations run, that's the choice the plaintiff makes. And if they make
what if
that,
the plaintiff didn't make that choice? Maybe the plaintiff did not know or didn't think that person was responsible or accountable for what has happened to them. So they decided not to sue them, right? And didn't think that a jury would hold that individual accountable, yet that person isn't added to a verdict form, and the jury disagrees with the plaintiff's assessment, right? What recourse does that plaintiff have to recover?
our statute of limitations as it exists today on most causes of action has a discovery rule built into it. So the statutory period begins to run from the time the plaintiff learns of the cause of action. And if that is how they learn of the cause of action, it is likely, in my opinion, that that is the point from which the statute may begin to run for that entity. If they really didn't know, then the statute runs from the time that they did.
Right. Okay. So you say if they did not know, but if the plaintiff doesn't believe that individual had anything to do with their injury, and so doesn't sue that person, but the the defendant rather, not the insurance company, the defendant wants that individual added to the verdict form. And I get your point about the statute of limitations, tolling or what have you, when a plaintiff discovers, or either they knew or should have known, right, or upon the discovery that they were that this person caused harm to them. But what if the plaintiff does not believe that the person caused harm to them, and that's the reason they did not sue them? Again, my question is, what recourse do they have to collect from that individual?
I don't see that as any different than the scenario we have today. If the plaintiff today believes that a particular individual that they know of didn't have any fault and they choose not to sue them, you have the exact same scenario today. I don't see that as a change.
All right. Thank you.
Follow up on that, because I actually don't like that scenario. I'm very concerned that you would say that I am in I filed my statute 2 months before it ran. I'm now I'm 14 months into discovery, and all of a sudden I'm allowed to reopen the statute. That's a 5-year potential statute of limitations, a 6-year potential. If I was an insurance company, I assess risk based on 3 years, not 5, 6 years. I mean, talking about inequities to me is that to me seems inherently inequitable. And I want to create a system where they have notice and they could be brought in, but not at a 5, 6, 7 year mark. That just seems illogical at a certain point, because discovery took 18 months, and now all of a sudden 18 months after statute of limitations has run, we're restarting the whole process. Nobody is served by doing that, right? I mean,
yes, but the point I'm trying to make, and if I'm not articulating it well, please forgive me, is that's the same thing we have today. If the plaintiff learns of a cause of action against a potential defendant 2, 3, 8 years after, on most of our causes of action, that's when your statute of limitations starts to run. Now, you do have, on construction cases, you've got a statute of repose. There's a section in 244 that deals with that, part of that. But I don't see the scenario that is being discussed at the moment as presenting a different scenario than what we have today with a statute of limitation. And when I say today, I mean what we've had forever, as far as I know, with a statute of limitations that begins to run from the time the plaintiff knows or should have known that the claim exists.
do you think, and I had the luxury last year of kind of going through some of this, and I'm reading kind of something that was drafted last year to try to address this. If the defendant says, hey, I believe you're really an at-fault party, you would agree that they're going to have to carry the burden of proof of proving that person has actual fault.
I think that's fair. I see that
I would go
as
beyond that and say there's got to be a determination that this other person was a proximate cause of the injuries, right? Which actually that's in the bill, but I fully acknowledge there's got to be a lot more meat put on the bones.
it's a variation of, and the idea that has always existed again, that a defendant has the burden of proof on an affirmative defense.
Sydney, come on down. We're gonna play Price is Right. Let y'all sit side by side. Bounce questions off you. And I'm going to say this, Jay. You have 10 minutes, and we're going to get you out in 10 minutes. But you two just kind of sit down, and we'll let y'all, and we'll just talk to both of you at the same time. Senator from Richland,
Mr. Chair, and back to you, Mr. Thompson. I promise you, I'm not beating up on you, okay? And I'm glad.
I believe you.
No, and I'm glad you're here today. But you mentioned that there is a remedy available to the plaintiff, and that way the law reads, when upon discovery, or when they either you knew or should have known, that is when the statute of limitations kicks in. But that's not exactly the same under the scenario that we're discussing.
Okay.
Because if a jury finds finds an unnamed party, responsible or what have you, to the plaintiff for his or her, injuries, there's already been a finding by the court, so I can't then, or plaintiff just can't sue at that point, right? I mean, there's already been a finding. Damages have already been awarded. And so it's almost like trying your case backwards. Okay, you've got damages now. Oh, but by the way, now we can file the lawsuit because there's a judgment that's been handed down from the court. I'm not aware of that sort of arrangement anywhere in our system of jurisprudence. So, again, I still struggle with placing or transcribing the unnamed party on a jury verdict. And then telling the plaintiff, well, now you go and, chase down, that unnamed party and collect. Or better yet, your cause of action now has, the statute of limitations has been told. So now you can go ahead and sue them. But even then, once you file a lawsuit, do you try the case all over again? Right? Because there's already been a verdict handed down. The person's already been accountable. Well, the person's already been, apportioned fault. Do you try the case again and you get a different jury? You get the same jury?
Sure.
Right. So that's what I'm struggling with. And that's why, for me, I don't think it's the same. I think it's different. So
I understand. I think I understand, but I don't agree. I do think it's the same. It's the same challenge that a plaintiff is faced with now. I think it's difficult for a plaintiff or for a plaintiff's lawyer to make a decision at the outset. Who should I and should I not name in the suit? That's not going to become any more or less difficult than it already is under existing facts and existing law.
If plaintiff's lawyers take a kitchen sink approach and just say, we're just going to sue everybody, throw spaghetti at the wall, sue everyone, then that is going to precipitate complaints about lawyers, filing needless or superfluous lawsuits. And we're right back here, whether it's 4 years from now, 5 years from now, having the same discussion. But, again, I certainly appreciate your perspective. I want to make an informed decision. As the senator from Edgefield has said, we're all here in good faith. We're trying to sort it out. And your input, as well as that of others, is very important. So that we're able to accomplish that objective. But again, thank you.
Thank you.
I was just going to add in a practical application. So when I'm considering filing a lawsuit, good lawyers don't throw in everything in the kitchen sink, right? We try and get that well clarified on the front end. Sometimes we're not able to if a statute's approaching and there's some ambiguity as to, for example, property ownership or who exactly was involved. But what I think and Senator Massey and I have talked about this, my concern about the non-party provision is it's going to invite lawyers to have to name everybody, and then they're going to be encouraged to leave everybody in the case to avoid the non-party ramifications that might develop during trial and thereafter. So what I think will happen is litigation is going to take longer. Litigation costs are going to go up, and it's going to take longer for cases to be resolved. If the non-party provision was in fact law, I wouldn't let anybody out. I'd say, no, we need to go try it against everybody and see what a jury says, because that doesn't do my client any good, So yeah, right now in Richland County cases, we're on like a 12, 18-month timeline before we have to be ready for trial. If you're adding a non-party in, that's going to be 36 months easily. Whether it becomes a question of who pays, which parties collect from each other, or does the plaintiff then have a new cause of action against the non-party? I understand the concern, but the non-party provision my opinion is that, and I practice every day, I try cases too. I think it's going to create more harm than good in terms of what we are trying to accomplish.
Unless you're the party that's going to get the responsibility for more than your share.
So I think that's when we always have to look back to a public policy decision.
That's right.
Yeah.
Yep.
So I think it's, it choosing the lesser evil essentially, and it's a balancing act. And when we're in a situation like this, wise people like you are the ones that have to make decisions when it comes down to a 49-51 vote. And that's what's on your desk right now, is trying to decide which way to go. But I think, if we've got so many proponents on this side and so many on this side, we have to look at public policy. I know it sounds cliche, but it is.
I think that's what we're going to do anyway, regardless of how many proponents or opponents we got. That's probably not going to affect us anyway.
I understand.
I do think that the substance of what we hear affects us,
Sure.
but the numbers on one side aren't going to affect where we come down, because ultimately, I think we've all heard from constituents on both sides, frankly, and we got to make the best public policy decision that we can make.
And Senator Massey, I welcome an opportunity to sit down with you.
I know you do, and,
Okay.
and as I've said to you privately, and I'll
Yep.
say I appreciate that.
Thank you.
Yeah.
And I'll bring Ashley. I'll bring Miss Creech with me as well.
Please do.
Yeah.
The South Carolina Defense Trial Attorneys Association would love to join you at that table.
Sure.
Happy to have a discussion, and I mean that.
We'll just do it sometime other than right now, right? We're like 227.
Thank you.
Anybody on the committee have any other questions? I want to thank you both for coming. And you laughed a couple minutes ago when I said I'd try to get you out by 2:30, and now you got 2 minutes. So
Thank you, Mr.
Yeah.
Chairman.
you're
Thank
welcome.
you.
Thank y'all. Thank y'all. We have been going at this about a little over 2 hours now. Anybody here? I'd like to keep going, but if we need to break for 5-10 minutes, anybody? Nope, we're going to keep going. All right, good. All right. I see that someone is here to testify about the construction defect for plaintiffs. Is there anyone to talk about that from the defense side? Russ, anybody? No, not today. All right. That's fine. Then I'm going to keep just working the list then in order. Denny Major. Will you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. Thank you.
Thank you, sir.
Senators, I appreciate the opportunity to speak today. I'm a litigator. I've been practicing since 2007. I'm a shareholder with Hainsworth Sinclair Boyd. Much of my practice has been dedicated to personal injury litigation defense, and I've represented a large part of that has been representing bars, restaurants in dram shop litigation. Most of those are small businesses, single location. And I've got to be honest with you, this is not my wheelhouse to be here. I try to stay out of politics. I try to lay low. But I decided that I would agree to come speak because I have seen how the system can be unfair to my clients. And I felt like I owed it to them to come here and speak to you today. I do acknowledge that there's also potential unfairness and inequities either way. There's no great answer here. I'm prepared today to talk to you about joint and several liability. That has been hashed out a lot already. I'm also prepared to talk to you about the dram shop pieces, which maybe haven't been touched on quite as much. Regarding the issue with joint and several liability, the obvious point here is that right now the plaintiffs have an absolute massive amount of control and really a carte blanche to manipulate fault allocation. And when I use the term manipulate, I don't mean that in a derogatory sense. The plaintiffs' lawyers are doing exactly what they're obligated to do. They're using the rules to the best of their clients' interests, and they're very good at it. Ashley White, I went to law school with her. We graduated together. I've had cases against her. She's a great lawyer, very smart lawyer. They're doing exactly what they're supposed to do. And that's exactly why I think that the rule needs to change. I think that Mr. Thompson really covered very accurately and thoroughly a lot of the points that I was going to make to you about the joint and several liability statute. there are a couple of points that I would add. I know that it was touched on regarding the set off and the wrongful death and survival allocation. I mean, I would emphasize that the name of the game, and again, they're advocating for their clients. This is what you do. You allocate all of the proceeds to the claim that maybe doesn't make the most sense. So in a wrongful death case, for example, you'll have somebody who perhaps maybe didn't survive, or very, very questionable evidence as to whether the person survived that crash or had any conscious pain and suffering. You're going to allocate that over to that survival action and then try it as a wrongful death. And it's not just that the trial could go that way. That's going to affect the way you settle the case, right? Because if I'm sitting there as a defendant, I'm looking at it, I know that if I'm left, I've got to treat it as if I'm going to have very little or no set off. And if you read that Jolly opinion that came out, I think it was Justice Kittredge issued the opinion. I mean, it's known that that's what plaintiffs are doing. But I think that it's resulting largely in double recoveries. And it would, a lot of times when we're paying policy limits, that is a reason, at least in the wrongful death context. And I don't mean to gloss over the other points that Mr. Thompson made, but I wanted to emphasize that. I also agree that there are mechanical issues that need to be worked through. If the bill was to go as it is now, the first issue that's going to come up is that an affirmative defense? And if it is an affirmative defense, do you need to specifically identify those at fault, the non-parties who you say are at fault in that answer? Now, as a defense attorney, when I see this statute come out, I'm going to put that in my answer for sure as much as I can, because I don't want to risk a judge saying I should have. I don't know what a judge would do with that issue, but that's going to be a legal issue. And the common law is equipped to deal with that. They deal with that issue all the time. So it doesn't necessarily have to be in the bill, but I can see that being an issue. And I would say as to the burden of proof and how it gets on what is the standard and how does it become that they're on the verdict form? I think the summary judgment standard is one mechanism where a plaintiff could file a motion for summary judgment and say, hey, there's not sufficient evidence that this defendant should be on this verdict form. There's not sufficient evidence of fault or proximate cause. That would make sense under the existing rules. A directed verdict too at trial, there could be a directed verdict motion by the plaintiffs. And I agree that the defendants would likely have the burden of proof there. And so it'd be the plaintiff saying, you haven't shown that this other party is at fault. So, maybe it would be nice to have some of those answers, but I don't think it necessarily has to be there in the legislation as it currently stands, because the common law is equipped to do that. And there are several states, Georgia, Florida, Tennessee come to mind. There's others, West Virginia. I really just looked at the Southeast that have this provision. And so the court would have something to look to when it does that. Regarding dram shop, and I know this hasn't been talked about as much, but I will say that that's operating in tandem. A lot of the problems you're seeing with these dram shop cases, it's a tandem where you've got this wrongful death, or you've got the joint and several liability problem, and a lot of times it's a wrongful death. So you've got the set off problem there. You've got this standard that's at best ambiguous under the Dram Shop Act, and then you've got time limit demands, and all of those things together are leading to some policy limits being handed over maybe quicker than people would like to, settlement wise. So. And just to cover that standard, obviously the current standard is knew or should have known. And we've got to remember the word intoxicated isn't exactly the clearest word either. And I think that it probably, when we get plaintiffs' expert affidavits, it's a lower threshold than maybe the general public thinks as to what it means to be intoxicated. For some people, it could be 2 drinks. And so you've got that, and you've got knew or should have known. So we'll see arguments in cases like, well, it was late at night, and so you had to know that person was out there drinking at other bars before they got there. It was 11 o'clock. Or, it was cold outside, and this person was just wearing a T-shirt. Obviously, he was intoxicated if it was cold. And you saw him in that T-shirt, and you knew it was cold outside. I mean, those are the kinds of arguments we're getting on this knew or should have known. And this proposed legislation, the visible intoxication standard, improves that for sure. I don't think there is a perfect way to deal with all of the dram shop problems, and I could talk about that forever, but it certainly improves it. It's a provision, a standard that we see in a lot of cases, a lot of other jurisdictions, I should say, that gives a little bit more certainty. And then there's the section, that subsection 2 of the provision in the proposed legislation that I think makes sense, because I get it, man. You can't just hand somebody over 15 shots of tequila and have them all drink it and say, well, I mean, he wasn't intoxicated when I served it. And I think that's what that's designed to do. I will say there's maybe a little bit of, I maybe it would make sense if that provision was more limited to just on premises drinks, because I could see plaintiffs' lawyers arguing, well, I mean, if I go buy 2 cases of beer and you say, hey, clerk, I'm going to go drink this at home tonight, and then I wind up hitting somebody later on or something, maybe that imposes some liability. There's a little bit of concern there, but I think overall this is an improvement to the current statute. I think the passenger liability provision, it makes a lot of sense to me, because that passenger is definitely in as good or better position to judge the intoxication of the driver. And so, I will say on this, make no mistake, I
Mr. Major,
agree.
hang on one second.
Yep.
You said it, and I want to get it while it's still fresh.
Yep.
This passenger provision, we talked a little bit about this the other week. I'm out with a buddy. We go out drinking. He's impaired. I'm impaired. He's supposed to be my sober driver. He's now obviously not. When you get to saying, well, I knowingly rode, well, if I'm impaired, my all of my mental facilities are diminished, probably greatly, depending on how drunk I am. Where do you then, I mean, how do you get around or address I'm drunk, I get in a car with someone who's drunk, I didn't know they were drunk, right? Because that's what I'm going to say. I'm going to say, no, I don't remember leaving the bar, more or less getting in the car with this guy. And so this whole idea of the passenger having fault, I get it. We need more. You should be responsible for your actions, man. I'm all about that. But when I look at this, I also think, well, you have silly 21 through 24-year-olds out doing dumb things, and I guess I'm having some heartburn with that. So if you kind of, from your perspective, tell me why that's important.
I mean, from that, I believe that if you go and you get impaired, you can't use your impairment as an excuse. I mean, that, you're subject to what happens. I don't think I can say, well, I was too drunk to understand. I mean, that's not that's not a defense that I think, I don't think that person should be allowed to recover from a bar if they go and start drinking in that bar and then they say, well, I just wasn't thinking clearly because I was drunk. I mean, that's not a place where I just don't think that's a valid excuse.
But do you think this section as written does that's 15.3.720? Is it actually, because what it says an individual is at least 21, prohibited from covering damages, knowingly rode as a passenger. That was with a driver who's visibly intoxicated, and that intoxication was the proximate cause of it. Knowingly rode as a passenger in a motor vehicle that was operated. There, I mean, again, I guess I'm trying. I struggle with the knowingly. Well, I guess it is a jury question, yeah. But part of the complaints I'm hearing, and Senator Edgefield, this is as much for you, is that it's the threat of the jury verdict that is causing people to pay their limits. If I'm bar X or I'm bar Y down the thing, it's that fear. It's not and so I guess I'm just sitting here reading it, and I'd love to hear.
Well,
yeah,
I'm sorry. Yeah, I completely agree with that statement. I mean, the fear of liability is a huge issue, regardless. I mean, and it's pretty hard to get summary judgment, right or wrong. I'm not commenting on that, but and then there's the issue of once you get to a jury, who knows what's going to happen. And so I agree that that is still a concern. I mean, but I think the idea was we're going to mirror. I don't know. The way I would read it, just looking at it from a third party point of view, is it's mirroring that standard for what the bar is. So, I mean, you've got at least the knowledge that the bar has. Now, in terms of, it's an improvement. It's not perfect. In terms of trying to make sure the claim is barred. I would love it if passenger claims just got barred, except for, maybe there is a situation where somebody's innocent. So where do you draw that line? I'm not 100% sure, but I think this is a better place to draw it than what we have currently. And I was just going to say, I also commend, I think this is a difficult issue, and I'm not here to say that restaurants and bars aren't, shouldn't be held accountable. And I'm also not here to say that there aren't issues. Listen, I'm a social person. I go out. I see that, there are issues that need to be dealt with my own eyes. And, the reality is the current standard isn't doing it. It doesn't seem to be deterring this conduct. And maybe it's because it's so ambiguous and difficult to comply with that why would you bother trying in the first place? This is not going to solve, it's not a silver bullet. It's not going to solve all the problems, but it is better.
Let me go back to because you said that this is attempting to get the individual inside the car, the passenger, and put them kind of in the same framework as the requirements that the bar has. But would you agree with me that the sober bartender has a greater degree of knowledge on whether or not that patron is drunk than their drunk friend who gets in the car with them?
I would not agree with that.
You would not agree with that, huh?
No,
and you don't have to. So.
If you're sitting, I've sat there at a bar drinking with my friends before, and I know what they're drinking. A bartender is maybe has a lot of other people. Maybe if it's just him and the other two people, maybe he's got the same amount of knowledge. But again, that impaired person, I just don't see how you can use that impairment as a okay, well, I was too drunk to know. That just shouldn't fly.
All right. I'm gonna switch gears on you because you're our dram shop guy of the day. Oh, I'm sorry. Senator from Charleston.
Thank you, Mr. Chair. I just had a follow-up on that. So would you agree that subsection 2 of that is more problematic than subsection 1? The difference being you knowingly rode with somebody who was visibly intoxicated versus you should have known that they were intoxicated. Going back to Senator Johnson's point about the drunk passenger, and even in here it says based on factors that would be obvious to a reasonable person, and we could agree a drunk passenger is probably not a reasonable person, and have the same knowledge that what we consider a reasonable person would have. So do you not think that subsection 2 at least is more problematic than 1?
I would agree with that statement that it's more problematic, but I also think that, a reasonable person standard is an objective standard. That's looking at objectively what a reasonable person in those shoes would do. It's not what a reasonable intoxicated person in those shoes would do. So I think that standard still makes sense.
Which would then distinguish that passenger from his example of the sober bartender.
Well, except for what would a reasonable bartender do versus what would a reasonable person do, but you don't get to take advantage of impairment is what I'm saying. I don't see why you should get to take advantage of
and I don't see it as taking advantage, because that person who clearly knew they had too much to drink and say, you know what, I'm going to put my keys down. I'm not going to put somebody's life at risk. And they get in the car with a buddy. Buddy had some drinks. Maybe they didn't know that. But then that's that argument. Well, you should have known that they were drunk. But this drunk or intoxicated passenger essentially, and we can argue about, chose to do what we would consider the right thing and not drive and catch a ride. Unfortunately, they just got in the car with the wrong person. I don't think that should bar them from recovery if they're injured then. Because then we're just telling people, well, in that case, and it could be argued, yes, they could have gotten an Uber and all this, but to punish them for deciding not to drive while intoxicated, I think is problematic.
I respectfully, I see what you're saying. I still believe if you're there and you're out with them, what they've been drinking, you should, I don't know that it's punishing them. They're getting punished for getting in the car with somebody who's intoxicated. And we're not going to let them recover under those facts. It makes sense to me, but I respect your opinion on that.
Thank you.
Anybody? Senator from Edgefield, I'll come to you.
I just say thank you, Mr. Major, for your comments on that. I would just say, I mean, you've because of your practice experience, and you've talked about this a little bit. If there are specific issues that you think we need to address, you mentioned the Jolly case and the issues that arise from that as it pertains to joint and several, or how we talk about the apportionment. If there's some additional language that you think we should include to make that better, that we can improve upon that, if you would send us some ideas on that, we're certainly, I mean, I want to try to fix the problems. So if there are things there that you can help, whether it's that or ideas on at-fault non-parties on verdict forms, what the mechanics of that might be, how that might work, or even specifically with stuff on dram shop. I know this is something Senator Johnson and I have both been interested in. We both had legislation on it. It was something we want to try to get at. If there are things that you think we can do to improve this language or his language or both languages, whatever, I think we'd be very interested in your help. And anybody else out there who practices in these areas, if you've got some ideas on this, we would love to have that input.
I appreciate that. And
Okay.
to be clear, that the Jolly case, I may have missed. I hope I didn't confuse you. This statute would take care of that set-off problem there, but the other thing, I appreciate it. Thank you.
Senator from Berkeley.
Thank you, sir. I got a quote. You mentioned earlier about the bartenders and holding them accountable for their service of their patrons and that. And to me, it's really hard. So I don't know if your firm has ever defended a DUI suspect or not, or anything like that. But so an officer, and I know it's two different courtrooms and that, but we're talking about criminal for a second. And so an officer who is trained for DUI is still always questioned as if he doesn't have the experience or knowledge, or they made a mistake while they're doing their procedures to work their way up to an arrest. And that ultimately ends up either being dismissed or pled down to whatever. But here we are, we want to hold a bartender who's had 30 minutes of education on the video, and we take their testimony or what they didn't do or did do, and we hold it at a higher scale almost than what we do with an officer who's trained, and we utilize that and in the civil court to sue the establishment per se. And I just want to see, do you think that's I don't know if you understand what I'm saying, but do you think that's kind of a fair? Yes.
And I mean, I'm aware from litigation. I mean, I've had experts that have pointed me to studies that indicate that, and I want to be careful with, I don't want to misdescribe them, but that really until somebody gets to about a 0.15, it's very, it's very difficult to tell. And even police officers will struggle until a certain level, even with all the nystagmus tests and all that. It's very difficult to determine whether somebody's intoxicated. And I completely agree. I mean, do we want bartenders to be given breathalyzers or conducting? I mean, it's tough, but there's not a great answer. I agree that it's holding them to a very high standard. I also agree that maybe, they could do better than they're doing as it is. So, but I think you're correct if I'm understanding your point correctly, that there's not a good answer.
Well, and listen, I'm all about holding people accountable. If they're falling off the bar stool or even a bar stool that's got arms and a back and it's got something to hold them in place and they're still falling off and you're still serving them, by all means, you should know better than to be serving somebody like that. And then allow them to walk out the door and get in the car and drive away. But for those who've walked in, have had a drink, and they've been at 3 other establishments and you don't know it, then I think that's hard to start holding them accountable per se, even with training or anything like that. So
I completely agree. I think that we are on exactly the same page on that point.
Thank you, sir.
Senator from Greenville.
Thank you. Mr. Major, you started off by mentioning the issue with set off and causes of action and the allocation between that. It was either Ms. Creech or Ms. Lynn talked about that there are circumstances where the court forces a reallocation. Is that, I don't have any experience with that. Can you
Yeah.
comment on that?
Sure. Thank you. So when there is, after a verdict, if there's been a settlement, and then the defendant after the verdict, who had the verdict against them, can challenge the allocation with the trial judge and say this was made in bad faith. And Ms. Creech mentioned that she's had judges that reallocated set off, I believe. I have not had that experience. The trial judge has a tremendous amount of discretion on that issue. And it's, in my experience, and you can read the Jolly case as an example of really not reallocating in what I view as a fair manner and still resulting in duplicative damages. But Ms. Creech is right that there is an opportunity to challenge that. It's just that it still is, I don't know the word. I mean, it's not operating well in my practice. And certainly if I'm settling a case and I'm looking at it, I'm thinking I've got to assume this trial judge is not going to help me on the set off.
In section 1 of the bill, and I know you spoke about some other sections, but the bill strikes section F of the joint and several statute. If from in your practice and with your experience with dram shot cases, if how much of a difference and what would it make if particularly possession of alcohol was struck from the exemption to our modified joint and several liability structure?
I won't say no impact. I will say very little. And that's because the plaintiff can still only name the defendants that they want to name. Right now, they will name the drunk driver frequently because they know they only have this subsection F, and they only need 1% on the bar to get full liability. So that would change. They would quit naming the drunk drivers, and they would really just name, they would try to whittle it down to get one defendant. So I don't think this would ultimately have a huge impact.
But if it was struck, it would take it from being 0.01% liable, and you could be liable for everything, to the 51%, over 50%.
That's true, but it's only going to be usually one defendant on the other side, and the jury has to allocate to 100%. And you're usually not going to have comparative negligence in these cases unless it's a passenger case, which.
Would that scenario impact, though, the example I hear, and everybody on this panel has probably heard, that if a person starts out at one bar at the end of pick any street you want to go to and go to the end, that first to the bars down the line, would it protect those folks who, if an establishment where someone comes in and drinks one drink at hours before a tragic incident?
A little bit, I think. I don't think it would have a tremendous amount of impact. I mean, that really, there shouldn't be any liability for that early bar with one drink. I'm not sure why they get named, but.
One more question. From your experience, from the folks you're defending, do you know if they do engage in alcohol server training, is that voluntary or is it a requirement of their insurer?
I usually don't get into what the insurance stuff is doing. I mean, I know that there's a lot of the tips training is what they call it, serve safe tips. My understanding is it's voluntary. I can't speak for sure as to whether insurance companies are requiring it.
If you don't know, that's fine. Thank you.
Sydney, in the absence of Mr. Berger, would you like to come down and address this? And Senator from Edgefield.
As she's coming up, I think to the senator from Greenville's questions and his point, if all you do is take out that part of subsection F, you still run into the problem. And I think Denny talked about this. If there's only one defendant, it's always going to be 100%, even if you're not 100% in the grand scheme of things, right? So that wouldn't have an impact there. If you don't allow non-parties to be considered, that wouldn't have any impact. Yeah, okay.
1% doesn't get you there, so to speak. Does that answer your question? Okay. I also just wanted to reiterate that the Jolly case, the trial court ultimately has to approve any allocation. So to the extent that there was any suggestion that plaintiffs' attorneys are manipulating the allocation, we don't get to do that unilaterally. Somebody has to sign off on it. So I did not want there to be a lasting impression that the plaintiff's bar is abusing that in any way. It's something that does have to be reinforced by our judiciary. And then last, I was just going to say that what really this conversation leads to is we need stronger DUI laws. We need there to be a more deliberate deterrent to discourage folks from getting behind the wheel, but to take more accountability for their level of intoxication, number one. And then number two, I think we need to come up with what visibly intoxicated means. Because if we can come up with something that everybody can live with, then that helps everybody, right? I think. Certainly people handle or process alcohol differently. I think it's going to be a reasonable approach. How many drinks have they had? You know, what's their body type? How much of that have they eaten anything? How long have they been there? I think we could hammer that out. But I think we need collectively a better definition of it.
I would like to say for the record, I really did not mean to suggest that the plaintiff's attorneys are doing anything. I would not use the term abuse. I think they're doing exactly what they have to do, which is represent their clients to the best of their ability. And I don't mean to suggest anything other than that.
Thank you for that clarity.
Yeah, and I don't want to suggest that either. I think you're absolutely right. I don't think anybody's doing anything wrong. In fact, I would think it may be wrong not to do it, right? Because you got to represent your client.
Sure.
To that extent. Now, that doesn't mean we shouldn't change the rules, but I think you're doing what you're supposed to do. You're representing your clients on that. But, you know, even with that, to the point that Ms. Lynn made about, yeah, the judiciary is involved. They got to approve those settlements, right? But then the real party that it's going to affect isn't party to the settlement, right? I mean, they're going to come later. And they're the ones who are going to be bound by that. Or I guess to Denny's point, and to Ashley's point, they get to make an argument to the judge later on. But yeah, the judiciary is involved in approving those settlements and those allocations. But the party that's really going to affect the next one isn't part of that settlement. So they don't get an opportunity to argue to the judge at that point, right?
I'm not sure if I'm following your example. Maybe
The non-selling party is not a party to the conversation about
Right.
how the settlement is
Right.
allocated,
Right.
but they do get to challenge it after
the fact.
Yes.
After the fact, and that's more of a discretionary type thing after the fact. Yeah, I mean, you're right. The judiciary is involved, and they're going to do what's fair. I mean, I don't have any question about the judges on that point, but not everybody's at the table, I guess is my point. And so it's fair in that context, but there's a larger context and not where people who are not at the table are not being considered, and it could affect them later on. That was my point.
Oh, Senator from Greenville.
Just briefly, both of you, I mean, I didn't perceive that either one of you were speaking critically of the other one. It helped me understand the frequency of which this happens, which my takeaway is it's possible. It doesn't happen much is what my takeaway on the reallocation of the damage between the fault, the
I mean, that's been my experience.
Yeah.
But I mean, I don't have like data to.
No, I get that helps me. The other thing to your point, I think we all would acknowledge that the requirement of the $1 million liability requirement. I understand the reasoning for it. I understand it's a balancing act, but to your point, that in and of itself has not moved us in the right direction with DUI fatalities.
it has not. You're right.
Have you both? And one, I want to say, I agree with you 100%. We need stronger DUI laws in South Carolina. And and I would hope that your organization will help lead that. And
Gladly.
I'm not chairman of that committee. That's Senator Campson. He's and help his committee get there, because we owe it to everybody in South Carolina to make our roads safer. Can you all, though, talk about subsection C in the dram shop part of it, where we're talking about selling alcohol to someone under age 21, and kind of the current state of the common law versus what we would be creating here? Because Senator Massey and I had a little back and forth at our last committee meeting about it, and I'd love to hear you two kind of give us some feedback on that.
Well, I'll be honest. I was thinking about this provision earlier. I have not. I've had cases obviously involving the sale to minors. I really haven't had one where there wasn't. There's always a pretty good argument that minor was intoxicated. So I don't know that I have experience with a case where this provision would impact anything. I think that, but I know that there are those cases that exist, and I just can't speak a whole lot to experience about them. I know, I think it's really trying to get at proximate cause, maybe, but I hate to speculate on what the intent of that provision is.
Edgefield.
Mr. Chairman, I think my idea was to treat under 21 like over 21, frankly. This gets to the conversation you and I had the other day. I've got difficulty with a first party action anyway. And so regardless of age, I got a problem with somebody trying to deflect fault. Like I'm drunk, but it's not my fault because, well, I was 20 years old, right? So it's all your fault for serving me. Everything that I've done is your fault. It's not my fault. And so I do, but I am curious as to how often you see first party actions, and whether that's even something that we need to talk about. But it's that provision in the common law that kind of got me going on this, and I almost feel like they ought to be treated similarly. That's kind of why I did that.
So what I take from that is, and it's helpful to hear what you were trying to do with the language, but I interpret it, a licensee that knowingly sells, serves, or furnishes alcohol to an individual under the age of 21 is civilly liable to that individual for damages arising out if the sale was a proximate cause of bodily injury, death, or property. So knowingly is critical, right? And I think what that speaks to is establishments that will or that do purposely look the other way.
Well, it's my understanding that the common law on this, and y'all are going to know this better than I do because I don't play in this sandbox, but that the rules are different. The common law rules are different on a dram shop action if it's a third party versus a first party.
Slightly.
And like my preference would be that there just be no first party actions.
I don't wholly disagree with that. I
Okay.
mean, because everybody should be held accountable for their decisions.
Right. But I left it in there to some extent, but I think if you're going to keep it, I think you ought to treat them the same. And I don't know, because I don't like just deflecting all the liability. So what I tried to do there, Sydney, was to mirror the language for over 21 with under 21. But I would be happy just saying there can't be any first party actions.
I agree with that. I mean, I think that's, if you were going to outlaw first party actions, maybe you'd make a distinction between somebody who's 15, you could start drawing the line somewhere else. But I think this makes sense and it's fair to have that standard. I would be okay with outlawing first party actions as well.
With the knowingly standard?
I think so. Yeah. If I'm understanding it correctly.
I think we should talk about exactly what we want to accomplish what we want to accomplish there.
You're correct. There is there's no first party actions if you're over 21, but to answer that question, that is the distinction.
You're wiping out the negligence per se standard for people under 21, right? I mean, because
That's basically the way it is now, right?
yeah,
That's the
because
current
it's
law.
negligence per se, and it currently that if you're
Right.
under 21 and I'm serving you, man, you're liable, right? I mean, it's boom, it's automatic. And I get the 18, 19, 20-year-old in 5 points argument, and I'm like, all right, I don't like them being able to file those lawsuits, but I have a real heartburn with the 17 and younger high school crowd who is getting served at at places.
Loosey-goosey establishments.
And then all of a sudden there's a heightened if we're going to have a kind of the negligence per se standard, certainly 17 and down makes sense, and that 18 to 20 is treated just like anybody over 21. And I view that more as a public policy issue than anything else, because you should be able to look at a 15-year-old and differentiate. And if you can't,
Then you
and I-
shouldn't be serving alcohol.
yeah, and
Yeah, and I think that to that point, I mean, I don't disagree with you on that at all. I think that gets more to a licensing
Absolutely.
issue with administrative and potentially even criminal penalties. If you're serving somebody who's 15
And they look
or
15.
12, then like we ought to be talking about more than just this, what we're talking about with a dram shot. Like,
I agree.
there's got to be there's got to be some different consequences involved in that scenario, because again, that's something that you really want to deter. And you want to deter all this, but you especially want to deter somebody who is serving and just like they don't care about the ID,
Absolutely.
they don't care about even if it's a fake ID, it's obvious, right?
Absolutely.
Right. There's got to be additional deterrence in that, and I don't think we accomplished that in the dram shop framework. There's got to be something else.
A criminal component or administrative.
Yeah, I mean, it's just, like I want to help the good guys and the ones who've never had claims before. But if there are people who are repetitively causing problems, or you're serving people who are clearly underage, there's got to be a different consequence.
And Mr.
Senator from Charleston.
Thank you. So subsection C, the way I read it, it does the opposite. It does not deter from selling underage. Now, if it was just the subsection C, but when you get to 1 and 2, because it's, if you knowingly sell to a minor, essentially, you are liable if there's proximate cause and they are visibly intoxicated. So it's almost as if, well, it's okay if I serve to a 16-year-old as long as they didn't look drunk, or I should have known that they were drunk. I mean, that's a loophole I see, an unintended consequence of that. That could be a defense. Well, but to your point, if we're trying to deter people from selling to minors, this does the opposite.
Well, unfortunately, Mr. Chairman, unfortunately, I think what we've heard and what we see is that the whole dram shop thing doesn't do a whole lot to deter anyway, unfortunately. I think in that context, it's the deterrence has to be more than what we're talking about here. I mean, I think my idea here was that in a dram shop scenario, we ought to have the same standards apply. And I kept in the first party action for a minor, even though I don't really like it. But I think in that context, in the dram shop context, you just treat it all the same. But there's got to be additional consequences, even higher if you're talking about serving minors.
I agree.
Not in the dram shop context. I think there's got to be something different.
I agree with that as well.
Anybody else? Thank you. Oh, I'm sorry. Senator from Richland.
This is not so much a question, but a comment. I think Senator from Edgefield was talking earlier about, I guess, trying to craft out a definition for what it means to be visibly intoxicated. Yeah, and so I guess what I would probably recommend is, let's not reinvent the wheel. I mean, we can look at our current DUI statute, which, addresses the issue of what it means to be intoxicated. I believe the definition is when someone is, their mental or physical faculties are significantly impaired. And so that may be the route to go, as opposed to, because the way it currently reads just says, where is it? Just looking at it. Pardon me. I was just looking at the definition. Here we go. Means an individual displayed visible signs and symptoms of intoxication that would have been obvious to a reasonable person. Kind of nebulous, a little vague. And I would probably go as far as to say, again, rather than reinvent the wheel, look at our current DUI statute, which carves out a definition for what it means to be under the influence, if you will. And so maybe some language that says mental and physical faculties appear to a reasonable person to be impaired.
Yes, Senator from Medfield.
You know, we and I appreciate that point. We had that conversation a good bit at our.
Okay.
We had a lot of conversation at our previous meeting when Mr. Berger was testifying. He'd suggested that we strike the adjective, right? The
Yeah.
Like
visible,
visible.
the visible,
We can
and
be
we had
okay
a
with that.
fair amount of conversation on that point. I do think that's something we need to work on. That's an area that we need to probably sit down with some people and see if we can figure out a good thing on that.
And certainly, you know, I am in support of anything that's going to um, promote deterrence, right? You know, make sure that our citizens are, you know, are safe. But I can tell you, as someone who has prosecuted DUIs, someone's practiced law now for 19 years, and I've seen the DUI law change at least 3 times. You know, from 2007, I think it was another change in 2000, and I think that was 2015, 2016. The penalties were a little more draconian. And now we're talking about change again. And certainly it's a conversation I'm willing to explore about what we can do to promote deterrence. I'm just not of the opinion that making the laws tougher would in fact promote or precipitate deterrence. And DUI is just one of those crimes or, acts of conduct when someone goes out there not thinking, well, I may blow a 25 tonight, or I may blow a 15. That's just not the way that most people think. You know, I'm of the opinion that we probably may have to start looking at ignition interlock devices,
Sure.
making that mandatory.
Sure.
And I'm not being facetious when I
I
say
understand.
that. I just, again, having seen DUIs as a defense lawyer, as a prosecutor, as somebody who, served as a municipal judge prior to running for elected office. I've just not seen tougher laws deter, that sort of conduct. And even with us, what we're doing here today, as far as, trying to figure out what's the best approach when it comes to dram shop cases and what we can do to deter that conduct, at least on the civil side. I'm not confident that it's going to have the desired effect of reducing, in any sort of measurable way, these sort of cases. So,
Senator from Edgefield.
Mr. Chair, I want to switch topics just for a second, but something that Senator from Greenville mentioned that I mentioned this now just because I'm hoping that people who testify at some point later on today, or if we have another subcommittee with testimony, that I'm interested in some input on this. And I thought about it when the Senator from Greenville mentioned it. And that is the $1 million insurance requirement for restaurants, bars, serve alcohol. I am interested, one of the things we put in this legislation was to clarify that the $1 million requirement would be per occurrence as opposed to per aggregate. And I did that because I know that there have been some carriers that have tried to get creative in providing coverage, and they've provided $1 million aggregate with some pretty low per occurrence limits. And that has allowed some places to get coverage. It also, and I don't know that restaurant owners fully appreciate the danger with that if it's $1 million aggregate, but it's a 25,000 per occurrence, and you got a bad dram shop situation, you're opening yourself up to personal liability.
Personal exposure, sure.
Because there can't be a lawyer that's going to give you a covenant or a release in exchange for 25,000 in a bad situation like that. So I put that in there to because I think that was really more of our intent anyway when we did this. But I am curious if there's anybody who has input about whether there would be any insurers in the market that offer $1 million per occurrence policy in light of the other changes that are in the bill, right? If we do the changes that are in the bill, would we have some carriers that would offer $1 million per occurrence? I think in the current system, we would not. But if we do that in conjunction with the other stuff, I would like to know if anyone could testify, and if it's not today, if you need more time, whatever, you could submit it, Mr. Chairman, written, whatever. I would like to know if doing everything else would affect that market to allow for $1 million per occurrence. Because if it wouldn't, then the effect of this would be to ensure that that there would be no coverage, right? And I don't want to do that, but also don't like the idea of a $25,000 per occurrence limit, because that's going to get you hammered. And I don't know that most people understand that. But if, as I think would happen, the rest of this stuff would have that impact, and I understand there are people who disagree with me, but if the rest of this would have the impact of lowering the rates, then I'm hoping that would have an impact. But I would like to have some testimony at some point, or some input on that point.
Noted.
Anybody prepared to give any of that?
We
We're
will
gonna do
get
this again
prepared.
next week.
Yeah,
trust
we'll
me.
get prepared.
All right, all right.
Well, I don't know. I don't know if you're the person to do that.
Understood. Maybe I'm, yeah, maybe I'm not. Yeah,
And maybe you are, but
probably not. I'm so we'll get prepared.
but I'm hoping that other people who are listening, and I'm
Sure.
assuming there's some people watching us online too, probably tweeting about it from their underwear in their mother's basement as we go along. But hopefully someone who is listening, if not here today, could give us
Speak
some
to the
help
effect.
on that point.
Okay, to clarify, you want information as to what effect on insurers willing to write 1 million
Yeah, I mean, it's
dollar
right. I mean, it
coverage
seems to me
if this
that
is
right now in the current environment, that there are very few, if any, carriers that are going to write $1 million per occurrence.
sure.
If we do all the other stuff that's in this bill, and if there are other suggestions and we do some other thing, whatever, but if we do the stuff that's in the bill, would we have carriers writing $1 million per occurrence?
Understood. Thank
Any
you.
other questions from anybody? All right, thank you too. Thank
Thank
you.
you.
As I have, apparently I'm now ringing the bell every hour. It's now 3:20, basically. We've been at this 3 hours. I'd like to go a little longer. We had 17 people sign up. I have efficiently gone through 6. So we are moving like mud. We are going to do this next week, and I want to get the testimony. I need to probably speed some of you up. But is there anybody who came a long way and who just like, I have to have my moment to tell us something? And before I do that, Senator from Edgefield,
I was going
comment?
to say, I mean, it has been kind of slow as far as number, but it's been good.
Oh, no, it's been
I mean,
excellent testimony.
The
Yeah.
testimony we've been getting has been very helpful, I think.
Mr. Chair,
Yes, sir.
I do know a constituent of mine is here from Greenville. So if there are people who are in the area, they could come back next Thursday. But if we can accommodate the people, like you said, who've driven from longer ways.
My goal is to go around 3:45 is kind of maybe wrap this up for the day. So. All right. Well, no, Senator, don't offer unanimous consent. You will ask no questions. There we go. All right. Whoever that is, come up and then kind of give us a name, and we'll. Yeah.
My name is Sarah Vining.
Yes. Ms. Vining,
Do I need to
you
raise
raise
my
your right hand. Do you
Okay.
swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
Good afternoon, Mr. Chairman and Senators. Thank you for having me. My name is Sarah Vining. I own a small business called the Hickory Post in Rock Hill, South Carolina. I'm also a member of the Small Business and Entrepreneur Committee in our city and a member of a nonprofit that has been adversely affected by rising insurance premiums in our state. I understand that this bill is intended to help business owners minimize the risks associated with litigation, to lower insurance premiums by restructuring the civil litigation process. My opinion is the Senate bill in its current state, 244, would adversely affect small business owners in South Carolina. I am concerned with the non-party fault on verdict forms that would make small businesses more vulnerable to lawsuits leading to higher insurance costs and financial instability. I take issue with the fact that my business could be named on a verdict form without me knowing, which would violate my right to a full and fair trial by a jury of my peers under the Seventh Amendment. I am further concerned about this from a personal standpoint, as my husband is a primary care physician and could be held liable in a case where he was not named in a lawsuit or able to defend himself. In both cases, being my business and my husband's practice, even if we were not held financially responsible, being named in a judgment could cause irreconcilable damage to our reputation and ultimately our sources of income. I believe this bill would ultimately give favor to large corporations and insurance companies. The threat of litigation would drive small business owners in South Carolina to no longer afford to operate. The long-term business effects of this not only apply to current small businesses closing, but other entrepreneurs being discouraged to start a small business, which would stifle growth and innovation in the state of South Carolina. I hope you will consider the main issues that I have in this bill, which is the joint and several liabilities issue and the issue of non-parties on the verdict form. Thank you for your time.
Any questions from anyone? Thank you, ma'am. Thank you
Thank
for
you.
testimony. Then there was someone from the Low Country who came a long way. Yes, sir. Come on up. And your name, sir?
John Hayes.
John Hayes. Find you on my. Mr. Hayes, if you would you raise your right hand?
Yes, sir.
You swear to tell the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Well, thank you, Senators and Chairman of the committee for letting me be here today. I'm here to speak about Section 6, which has to do with the construction defects. I believe this would be a bad amendment to this South Carolina. I think unintentionally it creates what I would call the perfect house trap. And what I mean by that is, if this was to be enacted, it would not only harm thousands of South Carolina homeowners, more than thousands, but also state agencies, hospitals, banks, colleges. Most people's largest asset is their home. What this bill seeks to do is change the effects of the building code in South Carolina. Now, the building code in South Carolina is the standard upon which all builders must build buildings. It is a minimum standard. It's not the gold standard, it's a minimum standard. And in fact, if you built a building just to the building code, in some ways you're building a D- building. What this legislation would do would make it so builders would only be held liable for violating the building code if you could show personal injury or significant damage. The building code is a statute. It's something that the builders are held to and responsible for. Just as if I'm driving up here from Charleston and I'm going 100 miles an hour and a police officer pulls me over, I can't, because I'm speeding, I can't argue to him, well, you can't give me a ticket because I didn't harm anybody. I didn't cause any damage to any cars. My colleague, Jesse Kirchner, could not be here today, but he has represented he's represented USC Aiken, he's represented the Strom Thurmond MUSC building, and currently some of the dorms on the College of Charleston. If this was to go into effect, it would negate the ability of this state to hold builders that build state property to be able to go back and claim and get them to pay for the fixes. We're talking millions of dollars here. The state taxpayers would have to fund that because there would be no recourse against the builders who didn't build the buildings in the first place. The issue you have with the statute of repose, and for anybody in the room who's not familiar with the statute of repose versus what the statute of limitations is, the statute of limitations basically says you have 3 years when you knew or should have known that you had a problem to sue someone. Fair enough. No one should sit on the rights. If you know you have a problem, if you know you have a lawsuit, you should sue somebody. You should operate within that time because it's unfair not to. What the statute of repose does, it says you cannot sue any builder after 8 years of completion of the building, no matter what, whether you knew or didn't know, whether you discovered there was a problem in 9 years or 10 years later. That's a problem because our buildings are not built to last 8 years. Our buildings are built to build a lot longer, whether it's a house, whether it's a hospital, whether it's an industrial complex. They are built to last a lot longer. That's why we have 30-year mortgages. People wouldn't take out 30-year mortgages on a house that only lasted 8 or 10 years. Right now, as it stands, the statute of repose says you have 8 years to bring that lawsuit. But there are exceptions, and that exception is if you violate the building code. Now, we've heard people speak today about per se negligence or per se violations, okay? What the statute of repose says right now is that a violation of the building code is evidence of per se negligence. Not that it is per se negligence, that is evidence of per se negligence. What the new proposed legislation would say was even if somebody did not do the building correct, you would have to prove a personal injury or significant, which is a very interpretive word, property damage. The problem with that is if it's a violation, it's a violation and should be corrected. The whole purpose of the building code is to protect the life, I mean, it says it right in there, protect the life and safety and welfare of South Carolina citizens. These violations are not minor violations. They're there because when there's a hurricane, when there's an earthquake, when something happens, that siding won't fly off the side of the house, that there's enough structure within this home that it will survive a minor earthquake or any kind of structural displacement. In your mind, it may seem like 8 years is a long time. It's not. And the reason I say that is these are homes and these buildings have latent defects. I don't use this comparison lightly at all, but it's very similar to cancer. You don't find it until it's sometimes too late or until they present themselves. The only way you would be able to find these violations is if you took it upon yourself at some point between the time it was built and the 8 years to start ripping apart your house, looking for problems. And that's not what we want. It wouldn't be cost effective, nor would it make any common sense. Now, this bill will only help large corporate builders and the insurance companies. It will help no South Carolina citizen whatsoever. It provides other problems. I have a client who allowed me to share this with you, Clifford Jones. He lives in Dorchester County. He has defective construction on his home. He made a claim after a large windstorm with the insurance company. And guess what insurance companies do not cover? They do not cover defective construction. So if there's a hurricane, a large windstorm, or anything that happens to your home, to your building, to your dormitory as a result of defective construction, the insurance company will deny that. So if Mr. Jones did not have the ability to go after the builder who made the problem in the first place, he would be stuck in kind of what I said a minute ago, the perfect house trap. And it gets even worse from there. Because not only in that situation, if this bill was to go through, are you faced with a situation where Mr. Jones or other South Carolina citizens can get no recourse from the insurance company, and they can get no recourse from the builder. They also, under one of the laws that y'all passed, which I think is a very good law, the South Carolina Residential Disclosure Act, the owner of the home has to pass on that information that there's problems with the home to any potential buyers. So they are stuck in a perfect house trap. I don't think that this section of the bill was meant to do that, but that's what it does. It will also affect banks. Banks have these 30-year notes. If they have notes on homes that are practically worthless because they have construction defects and there's no solution on either side, that'll cause a problem. Fortunately, right now we have a system that allows the person who caused the issues with the home to be pursued. You're not going to find a construction defect very rarely on a home or building that's 3, 5, 6, 7 years old, because they don't come to fruition. Like I used the analogy earlier about cancer. They just don't come to the fruition at that point. As far as, the benefit to the insurance companies or the builders. Builders right now are making more money than, to my knowledge, they ever had. The 3 top builders in the nation, which also operate here in the state of South Carolina and build really most of the homes here, their shares have gone up over 100% in the past 5 years. Out of the top 3, you've got one who made $34 billion in 2023, one that made $15 billion, and one that made $35 billion. This bill really helps no one in South Carolina. Might help the insurance companies because sometimes they do have to pay these claims when they are the ones that insure these builders under certain circumstances that did this defective work. It's a little amendment that has very large repercussions, and not only for the homeowners, as I said before, but there's those examples I just gave you. If those cases I cited earlier, the College of Charleston, USC Aiken, and MUSC Strom Thurmond, the legislator would have had to appropriate $1 million more. When I say million, not 1 million, millions of dollars more of taxpayers' money to pay to repair a building that they paid good money for in the first place that wasn't built correctly. So it affects them. It also affects office building owners, people that own doctor's offices, dentist offices, and any kind of office you can imagine. It's simply a standard that needs to be kept. And this amendment would change that standard at the cost of South Carolina. Be happy to take any questions or discuss.
Senator from Charleston.
Thank you, Mr. Hayes. I do have a question. This new language, a violation is considered material only if it exists within a completed building, structure, or facility. Do you see that?
I do.
Now, I've built a lot of things. I've built boats. I've built homes. That seems particularly onerous, and you tell me if I'm wrong, but basically that provision is saying, even if you're aware of a building code violation during construction, like on your foundation, for example, that violation you can't address or litigate over until such time as the building is completed. So you have a faulty foundation and you have to build the rest of the house before you can bring
That's correct.
a cause of action again for your bad foundation. That's the way I read this.
As it says, yes.
You agree with that?
I agree that that's what it says. And I believe that's how it'll be interpreted, because otherwise it wouldn't be in there. It specifically points out a completed building.
Yeah. I mean, that is crazy.
It's
if you got a bad foundation, then you need to.
Yeah, you need to wait.
You need to tear up the foundation and put a new one in before you build the rest of the house. But this apparently is making you complete the home.
I agree wholeheartedly.
Okay, thank you.
To follow up on that, Mr. Hayes, sometimes we're reading these out of context.
Right.
Isn't this the loophole after the 8-year statute of repose has ended? This is not, I would agree 100% with the senator from Charleston. It would be insane to create a rule that said while my building is being built that I couldn't stop it.
Right.
But this addresses the time frame after the 8-year period has run, and these are the only loopholes that allow me to then bring a suit against that builder. Because we're reading it out of context of the code section that it is within.
Well, the code section it is an exception to the statute of repose, which I discussed, which is 8 years. That is correct. But it also addresses what is evidence of negligence in violating a building code. So it does apply it can apply further than just where it's written in that particular section, because it does define.
I'm not necessarily a fan of this, but I want to make sure we're reading it in context
Right.
of how it applies in it as well.
So what? I'm
ahead.
sorry.
No, you go ahead and
so
answer the question.
What this does is, the current statute of limitations is 8 years. There's an exception to that, or loophole I like exception, but we can say loophole, whichever you prefer, Chairman. But that says that if there's evidence of a building code violation, that is evidence of per se negligence, which then allows you to go past the 8 years. Okay. The problem with changing that as well is it will be interpreted to say, and I believe it will say, that a violation of building code, whether it was after 8 years or before 8 years, is not evidence of negligence per se. But the other problem with that is when we go into this and we talk about the 8 years, the reason that exception is there, well, I wasn't there when they wrote it. And, as Senator Massey said earlier, talking about different sections, who knows what the intentions were or not the intentions, but we know what's written. But back when this was changed, back in, I believe it was 2005, we have to believe that this was changed to allow that exception because buildings do not show these problems within 8 years, right? Now, and that is why the statute of repose in this 8 years in this bill, the way it would change it is a problem. Now, as it's written, as it stands right now, the one that's forced in effect in law is good, and it has that problem. I agree if something's done, that's not a violation of a building code, then we can talk about it. But when it's a violation of a building code, when somebody gets caught for violating a building code, they shouldn't have a get out of jail free card, whether it's 3 years, 5 years, 8 years, or 10 years. Because these code violations, there's no way to know about them until they fester, until they present themselves. I get asked this question by my clients all the time, and I'm going to go ahead and address it. It may not be a question you have. They say, well, how did this happen? Why? We have building code officials. Why has my house had these problems? Isn't the building code official responsible? The answer is no. And the answer is no because they're not there when it's being built. A building code official goes by every so often to check a box. They are not there when every window is put in. They're not there when the roof is put in. They're not there when anything's put in. They get to see it at certain stages, and most of the stuff is covered up at certain stages. I've used this example before. Trying to hold a building inspector responsible for missing building violations is like trying to hold a highway patrolman responsible for not catching every speeder. And that is why the buck stops with the builder. Follow the code. The code is a minimum standard.
Thank you, Mr. Chairman. And I'm curious if we have anybody who can speak to this issue as well. Because I mean, with all due respect, I read the statute differently. I read it as the existing law saying this is an exception to the statute of repose. So it's an exception after the 8-year period that you mentioned. But that the exception is if there's any violation of a building code, that gets you to the exception. The language here says you got to have a violation of a building code that actually causes some damage.
Well,
and the damage requirement is not in the existing law. So the mere fact that there's a violation of a building code by itself, if it doesn't cause any damage, doesn't get you the exception. But this would put that in there. But I may be reading that wrong, and I want to see if there's other people here who have a take on this as well. I mean, I appreciate Mr. Hayes' testimony, and he's certainly more learned in this area than I am. But I'm curious if there's anybody who has a different take, because he may be absolutely right. I'm just wondering if there's any other position on it.
If there is anyone, now is the time to come on to the podium.
Then maybe he's right.
All right. Well, and Russ, I'll say, if you'd like to bring someone next week to kind of, I am happy. We can hear from Mr. Hayes today, and then y'all can, unless you feel very confident, you can be up here as well. If you'd want to, I just want you to have your best expert to come and give us their thoughts. Okay. All right. That okay with you, Senator from Edgefield?
Yeah, that's fine with me, but I also want to give Mr. Hayes or someone else an opportunity to be part of that conversation.
I would like to be part of that conversation.
Yeah, I mean, you should be. Yeah.
My colleagues as well.
Right. And whether it's you or somebody else, if you can't be here, if we could have somebody here, because I would, this is an area where, Mr. Chairman, I need two people with different positions sitting at the same table so that we can have that conversation. Because it was not my intent to do what Mr. Hayes has articulated. If it does that, then that's a real problem.
And Senator Massey, I appreciate that. That's why the very first thing that came out of the mouth was unintentionally created a house trap, because we're all here. Everybody in this room is here for the best interest of South Carolina and its citizens. So I don't think anything was done intentionally. It's just
the intent was just to ensure that if there's a building code violation, that there's some damage that resulted from that, as opposed to just a general building code violation. But I need somebody to help with that. So I appreciate you're bringing that to our attention. And if we can have somebody else at the next meeting, Mr. Chairman, and if Mr. Hayes can be here to help kind of work on that, or if there's somebody else, that's fine.
I will do my best to be here. And if there's somebody else that can be here, we'll have somebody here come rain or shine. And I'm also happy to, I know y'all's time is precious, but I'm also happy to speak with y'all at any time or meet with y'all.
Thank you. Any other questions for Mr. Hayes? Thank you, sir. We have been at it about 3.5 hours, and I am so. Senator, did your constituent? They did not. He can come back. All right. I have found, yes, sir. You can go. I have found that we're averaging about 30 to 40 minutes per person. I'm sorry for those who are here. We're going to try to do this. This is kind of this has been really good conversation. As Senator from Edgefield said, you all are enlightening us and really getting into the details of the law, which we often can struggle with if it's not your area of expertise. And so you've helped. Many of you in your testimony has explained that. And as long as we are having that kind of dialogue, this committee will meet. But I've been very clear, when that kind of begins to become repetitive and end, we're going to start having that conversation here so we can have amendments, because it is my intent to have a bill, move it out. I'm not going to say as quickly as possible, but at an appropriate time where this committee has been able to hear all the testimony and weigh it and then debate amongst ourselves. With that being said, I think we're going to wrap up for the day, and we will try to post notice on another meeting. Just based purely on time, it may be appropriate to have 2 meetings next week. But of course, that's going to come down to everyone in this room's schedule and how we do it. But I'd like to try to move some things along here. But with that, if there's a motion to adjourn, we could be done. For a second, all those in favor say aye. We are adjourned. Thank you all.